that opportunity of hearing has not been there, but directed me to get the copy of the entire order sheet. And that's why now the appellate court, my lord, has sent it the file, entire file to the Barampur, my lord. I have applied there.
But Mr. Chand, that is a matter arising out of the PP Act.
Yes, my lord.
OPP Act. So how is it in writ? Why not in appeal?
My humble submission, my lord, since it's a case where no opportunity has been given and against the order of the state officer I have come.
And there is an appeal provision.
No, alternative remedies also, my lord,
yes.
permissible, my lord. Alternative remedy.
Discharge is the authority.
No decision, no decision, I say. No, I'm sorry, man. Decision is not the authority.
Kindly see section 9. Do you have a OPP Act? No. I'll give it to you.
IDCO, my lord. Not that exactly. IDCO is the authority.
Sir, IDCO ra state officer under section 4 OPP Act provision re apan ko order pass kale. So once the OPP Act is under implementation, the authority is the appellate authority.
My humble submission, my lord, subject to acceptance, my lord. The state officer has not passed any final order. He has not passed any order. He has simply accepted the authority's report that the particular structure
under section 4 of OPT Act or not? OPP Act?
Yes, my lord. Yes. That is there.
So any order passed under section 4A(1) has to be appealed before the district judge. Second page, section 9.
Yes, ma'am. Section 9.
This order has been passed in section 4 and section 9 is appealing.
We are disposing of this matter, giving you opportunity to approach the appellate forum.
Time limit is there, but
that
I have also the copy.
Annexure 5. 23-24 ପୂର୍ବରଟା ଅର୍ଡରଟା ହେଲା under section 8 paste annexure 4 extract of order in EUA case 1557 of 21.
Is from this page 25. The petitioner, C.DASH, has filed this writ petition.
Next at 10 for hearing 5/1/2024.
Challenging the very initiation and subsequent completion of EUO number 1557 of 2021 by affirming order of symbolic possession of the petitioner leased land to be declared illegal, arbitrary, and to be quashed. With a further prayer for a direction to the opposite party to allow the petitioner to continue with the possession of the leased land as per Annexure 1 in accordance with terms of lease till end of lease period. The order challenged here is passed
under section 4
of the Orissa Public Premises Eviction of Unauthorized Occupants Act 1972. Section 9 of
9(1).
the 1972 Act provides an appeal against the order passed. Under section 4. The learned counsel for the petitioner seeks permission to withdraw the application to approach the appellate authority and further submits that since there is a prescribed period for filing the appeal, in case the petitioner files the appeal, the delay, if any, be condoned and his appeal be heard on merit. Learned counsel for the state has no objection to such prayer. Who is the IDCO authority?
My lord,
It's
it is opposite part number. No, appeal has to be preferred before the divisional commission, my lord. Revenue divisional commissioner. 1A.
Considering the submission made by the learned counsel for the respective parties, if any appeal is filed within 2 weeks from today,
Right.
the with an application for condonation of delay, the delay application shall be considered in accordance with law favorably, keeping in view that the petitioner approached this court challenging the order in the state petition for which there was delay in filing the appeal, and thereafter the appellate authorities shall proceed to hear the matter on merits. With this observation, the writ petition is dismissed.
May I pardon to make a mention, my lord? Item number 35, my lord. It has come so to my lord for recalling the order 18/11/2024 for type out the correct of order. My lord, may I crave my lord before rising, my lord, I'll take of this.
We'll go to this. Yes.
Item 35. Obliged.
My lords, item number 34. Humbly pray for modification of order.
Let's wait till the matter is resolved.
Land acquisition matter.
Yes.
My lord, I am behalf of Santosh Samsray. Item 20 may be adjourned to some another demand.
Let us wait till the matter.
28.
Yeah.
Quickly list item number 1.
My lord, item number 1. May I audible, my lord?
Yes.
Item number 1, my lord directed the Union of India to submit a rule if the rule is available with the authority or not. The rules is available. I got the document, but and also instruction has been received. If Lordship give a 3 days time, I'll next Monday Lordship may take it up. We'll file an affidavit. I don't want to give this way. But rule is there. That is
in 11 also taken same plea.
No, I have not taken the. I have received the and taken time. No, it is wrong submission. Last time I have took time, but I have got the instruction and rules, and that's why I am submitting affidavit. That submission I have not made by. I'm sorry, my land friend might have
82 rules.
82 rules.
Yes,
We have.
The-
Last occasion we also blank about whether the rules available or not. Because I also confused. Now they are provided.
The Solicitor General for the Union of India, along with Kahana Lekhao.
And my lord, CDF का ना I'll pass on the slip, my lord, to the court.
Okay.
मैं पूरा court रा सब list दे दूँ.
All right. Submits that is now
Obtained the rules and
yes,
all
now
documents.
National Water Development Agency Contributory Fund Rules 1982
27A of the 27A of the
and some instruction which you will file by way of an affidavit within 3 days, giving copy to the learned counsel.
within 7 days, my lord. After 7 days, I will file.
You
So
want it
affidavit
to be taken off next week, you said. That is why.
next, sorry, sorry.
Uh,
10 दिन कौन दियंतु एटी और also locally करिवे.
uh,
3 दिन 7 दिन 10 दिन
within a week,
Yes, my lord. In the new.
copy to the learned counsel for the petitioners. Put up this matter in the week commencing from. So let it come on a. If you want 10 days time, then it will come on 16th.
Yes, my lord. Yes. Yes.
16th of December 2024.
obliged.
Yes, obliged.
Along with Lekki Deve, is you just think of obligation.
आगे आगे.
ନା ଗୁଡାକ ଦେବେ ମିଷ୍ଟର ପାରି ତାଙ୍କ ନାଁ ଗୁଡାକ ଲେଖିଦେବେ କିଏ କୋଉଥିରେ ରହିବେ।
Item number 2.
Last order, kindly have a glance. 12/11/24, my lord.
My lord, here we didn't receive the instruction man from railway.
Instruction was to be obtained.
Yes. So for further 10 days time maybe. School style 10 days will be.
Mr. Pari, the last portion is of the order is that you are to obtain instruction whether the petitioner preferred an appeal or not, and if so, what is the result of the said appeal?
We sought for the instruction, my lord. We have not received the school railway matter. Let's say we give 10 days time.
Deputy Solicitor General of India submits that as per order dated 12/11/2024, he has already sought for instruction in the matter, and the matter may be taken off a week after. It is this matter in the week commencing from 16th December 2024.
Obliged.
Item number 3.
May I please, Your Lordship? Your Lordship, I'm challenging the order dated 1/2/2024 passed by the learned Central Administrative Tribunal Cuttack Bench Cuttack, wherein the prayer of the petitioner challenging the punishment order of compulsory retirement from service has been dismissed, Your Lordship. Your Lordship, the petitioner was served with a charge sheet, Your Lordship, which contained 2 articles of charges. First was that he prematurely closed the RD account without collecting the original passbook, Your Lordship, and caused a pecuniary loss of 11,000 to the department, Your Lordship. In the first article of charge, the allegation was that, Your Lordship, that the signature of the depositor did not match in the voucher, and hence it was alleged that the petitioner misappropriated the amount and caused a pecuniary loss to the department.
What
And the
punishment
second,
was imposed on you?
yes, Your Lordship,
What is the punishment imposed by the
compulsory retirement from service, Your Lordship.
Mr. Pari? Mr. Pari,
Yes, yes, my lord.
it's a case of compulsory retirement, so the way has been dismissed. Let the notice be issued and you take instruction in the matter.
Yes, my lord. Yes, I'll take it.
The petitioner, Lakshman Behra, has filed this writ petition challenging the order dated 1/2/2024 passed by the learned Central Administrative Tribunal Cuttack Bench Cuttack in OA number 384 of 2021, with a further prayer to pass the charge sheet dated 2/9/2016. The inquiry report dated 18/7/2018, and the punishment order dated 25/2/2019, and also the order dated 11/12/2020 passed by the appellate authority. peruse the writ petition. After going to the averments, heard the learned counsel for the petitioner learned counsel, Deputy Solicitor General for Union of India, issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Padi accept notice for all the opposite parties. Extra copies of the writ petition be served on the land council within a week. Matter will be listed 4 weeks after. Counter affidavit, if any, will be filed in the meantime. Yes.
Much obliged, Your Lordship.
Item 4, my lords, I was to take instruction, my lords. So I haven't yet received, my lords. May kindly give me a short date, or 10 days, my lords. I'll definitely get the instruction.
What instruction, Mr.
My lord, whether the under the Forest Conservation Act, Kuchila Bana
Kochila
comes within
comes
forest land.
under the
The
forest.
Tahsildar is to give that instruction.
Okay. Mr. Naik, learned additional government advocate, takes some more time to obtain instructions as per the order dated 28/10/2024. Put up this matter. Even put a saptah for it. Obliged.
Item number 6.
I am appearing today.
What do you want?
In this case, I am appearing today, filing
You
Vinam.
filed Vinama.
My lord.
You want your name to be reflected in the cause list. Your good name is Surya Narayan Biswal.
My lord. Surjanaran
Mr. Surya Narayan Biswal and counsel submits that he has filed Vinama to appear in this case for the petitioners. Let the registry place the Vinama on record and the name of the land and council be reflected in the cause list henceforth. Put up this matter in the week commencing from 9th December 2024. Aras of Taras, you get ready.
Item 7.
May I please, Your Lordship? The decision was taken by the opposed parties to acquire lands of the petitioner's village for the purpose of Rengali irrigation project up to 100 foot from the river level.
Your representation is annexure 4.
My lord, that is also
You have
pending.
got no response
No
from
response.
the authority.
No, my lord.
Annexure 4 to be disposed of.
Item 8.
Lordship, I'll see the last order dated 13/11/2024, madam. Instruction ମୋର ପାଇଁ କହିଥିଲେ।
कौन आसिला आपनकर इंस्ट्रक्शन आसिनी आरो सप्ताह रखियो
Whose representation is pending under Annexure 5?
no see we have asked you about the status of annexure 5 did you
For the matter referring to the civil court for its proper adjudication.
ସେଇଟା ହଉଛି main କଥା ଆପଣ ରେଫର କରିବା କଥା ଏତିକି ପାଇଁ ସେ ଦେବେ ପିଟିସନ ତ ପକେଇକି ବସିଛନ୍ତି ଆଉ 30/1/2024 the land council is Bhavani Shankar Rai Guru, land central government council has filed the appearance memo, which is taken on record. आपको ना लिखा हुआ नहीं मिस्टर पाही को ना दरकार नहीं. All right. The Land Council submits that as per order dated 13/11/2024, he is yet to receive instruction in the matter, and the matter will be taken up next week. Place this matter on 9th December 2024.
I pray one thing, my lord. Lordship, till that period, not to disburse that amount, my lord.
ये तो जीवो सेठी जीवो
ଆଜ୍ଞା ସେଠିକି ଯିବ ସେଠିକି
ଖାଲି
ଯିବ ଯଦି
refer
ପଇସାଟା
କରିଦେବେ
ରିଲିଜ କରିଦେବେ ଅନ୍ୟମାନେ ମାରି
ହେଇଯିବ ରେଫର କରିଦେବେଣି କଣ ହେଇଥିବ ଆପଣ ଜାଣିନାହାନ୍ତି ଲାଟେଷ୍ଟ ପୋଜିସନ କଣ ୟେସ୍ ଆସ ତେଲଙ୍ଗୁ ଟିକେ ପାଢିଙ୍କ ନାଁ ଦେବେ.
Item 9.
Procedural pass similar orders. Initiation of arbitration under 3G5 of NHI.
It has been sent to the arbitrator cum collector, not yet initiated.
Not
ତାଦେହରେ କିଛି ଚେଞ୍ଜ ଚାଞ୍ଜ ଦରକାର କି ନମ୍ବର କିମ୍ବା ଅନେକ ଇଏ କିଛି ଚେଞ୍ଜ ଚାଞ୍ଜ ଯଦି ଇନକର୍ପୋରେଟ କରିଦିଅନ୍ତୁ ତାକୁ ଦେଇଦିଅନ୍ତୁ. Dispose of.
Item 10.
Carry out for this.
May I please, Lordship? Our petitioner's land has been acquired by the Bhushan Steel by notification dated to her 2008, my lord. Yet not disbursed, my lord. She received the notice in 2012. In between, her husband has been died, and the amount is 10,26,356, my lord. Yet not disbursed, my lord.
କେବଳ ଲେଖା ହେଇଛି ଆପଣଙ୍କର ଦେୟଟା ଲେଖା ହେଇଛି ଏଟା କାହାକୁ ନୋଟିସ ହେଇଥିଲା ବିଭୂତି ଭୂଷଣ ସିଂ କିଏ
Husband expired କରି
ଆଉ କଣ କଲେ ଆପଣ 2012 କେମିତି ଜାଣିଲେ ଡିସବର୍ସ ହେଇନି ବୋଲି ଆପଣ 12 ବର୍ଷ ପରେ ଆସିବେ ଆପଣଙ୍କ ସ୍ୱାମୀ ମରିଗଲା ପରେ କହିବେ ଡିସବର୍ସ ହେଇନି. So
the claimant has died after 10 years.
Mr. Nayak,
My lord.
ଦେଖନ୍ତୁ କାଳେ ଡିସବର୍ସ ହେଇଛି କି ନାହିଁ ତାପରେ
Well, I'll take instructions accordingly.
This writ petition has been filed by petitioner Sanjuwala Singh with a prayer for a direction to the opposite party number 4 for disbursement of the compensation amount as per notice under Annexure 3, which is dated 23/8/2012, issued in favor of her husband. The Learned Counsel for the petitioner submits that the petitioner's husband has not received the compensation amount, and he died on 22/7/2021. In support of the submission, she has annexed the death certificate to this writ petition as Annexure 4. Learned Counsel for the state seeks some time to obtain instruction as to whether the compensation amount as per Annexure 3 has been disbursed in favor of the petitioner's husband or not. Put of this matter
From 16th, my lord.
In the week commencing from 23rd
My
December
lord.
2020.
Obliged.
Item 11.
11 pray for adjournment. Item 11 pray for adjournment.
It is coming for the first time.
Yes, ma'am.
The Learned Counsel for the petitioner seeks for an adjournment. Give adjournment.
Item 12.
Please, lordships.
I need some time, my lord, because it is what instruction I have got that sell deed has been made when the charge of the bank is continuing. And it is a matter related to surface act. But I have to collect so many documents to prove that when my charge is continuing, let it come on week commencing 16th. I will come up with a counter affidavit. My lord has directed me file the counter affidavit.
Mr.
Lordship,
Item number
12.
12.
18/11/24 was there.
Item number 12. State Bank.
item number 12.
12.
Lordship.
Just.
Sheikh Sitarullah
Again.
Sitarul item.
versus collector Khurda. And 14 payment 14 pending achla ki section 14 pending thila.
Section 14 ne pending. Possession notice place ହେଇଛି section 13(4) ରେ ଯୋଉଟା paper publication ହେଲା ଏଟା paper publication ହେଲା October ରେ, and challenging that he has come. That he is saying that I am having, there is a sell deed in my favor. I am continuing with the possession. So we, but his vendor has created charge by it.
But Lordship, record of right is in my favor without ghosting.
Let him file the obtain Mr. Gurudatta, Learning Counsel, appearing for the State Bank of India. 6
What's collector family?
Collector and others. Opposite party number 1 which is State Bank of India. এটা ভুলে লিখি collector correction for the opposite party collector correction for the and that he has to obtain a detailed instruction in the matter and file a counter affidavit. Place this matter in the week commencing from 16th December 2024. Copy of the counter affidavit be served on the Learning Counsel for the petitioner in advance.
Item 13.
Password
Item 14.
Well, the Orissa government land settlement matter, Millard. Annexure is pending, Millard. Representation is pending, Millard. Similar order may be passed.
Annexure 3.
Millard.
Please. Correction. Annexure 3 ଅଛି ତ ତା ଦେହରେ
correction କରି ଦେଇଛି.
Item 15. Item 16.
Lords, I'm on virtual mode. Lordship may see order dated 26/11/2024. And accordingly, I served a copy on senior counsel, Mr. Mahanti, to take instruction. This is a RITCO matter.
Your Lordship, we have just received the para-wise. We will be filing our comment.
Para-wise comment you have already received.
Yes, Your Lordship.
The Mr. P.K. Mahanti a submission is made on behalf of Mr. P.K. Mahanti, learned senior advocate appearing for the opposite party, submits that he has already received the para-wise comments in this matter and intend to file the counter affidavit, and the matter may be taken up a week after. This matter in the week commencing from 16th December 2024. Copy of the counter affidavit be served on the Learning Counsel for the petitioner in the meantime.
Bless you, Lordship.
Item 17.
17 on behalf of Madam Jena, may kindly be passed over.
Just praying for item number 15. 15, it has
we
been
had just passed over.
Passed over. Just a minute. Yes, item.
Item 17 on behalf of Madam Jena, may kindly be passed over.
All right. Yes, Mr. Das, please come.
Item number 15.
With leave of your lordship, my lords. I am aggrieved by the order dated 1st of April 2024
That is Annexure 12 to your Lordship's brief at page 84.
What order has been passed?
The order is, my lords, I am aggrieved by my premature retirement or compulsory retirement from the railway services as a peon. The allegations was that I induced
For the Mr. Padhi,
My lord.
it's a compulsory retirement from service. So we are issuing notice to take instruction.
My lord.
Grateful,
The
my lord.
petitioner Keshav Chandra Patron has filed this writ petition challenging inter alia the order dated 1/4/2024 passed by the Land and Central Administrative Tribunal Cuttack Bench in OA number 549 of 2017 in dismissing the OA and thereby confirming the order dated 27/7/2007 of the disciplinary authority, order dated 11/6/2016 passed by the appellate authority. Imposing punishment of what punishment was imposed?
Removal of services.
Punishment of removal from services. Stop. कहाँ ना लिखा वो दिल्ली जनता पढ़ो ऐसी जो लिस्ट आशी तो लिखी देवे मिके पीके पढ़ी और का संगे issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Since Mr. Padhi is appearing for all the not all the opposite. Who is this opposite party number 5? Opposite party number 5 is a private party against whose transaction I have been saddled with the punishment. It is a private transaction alleged. Opposite parties number 1 to 4 and extra copies of the writ petition be served on him. So far as OP5 is concerned, requisites for issuance of notice on opposite party number 5 by speed post with proof of delivery shall be filed within a week. Matter will be listed 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yes. Good.
Item 18.
Covered matter, my lord. Covered by your lordship.
The number गुड़ा को किसी correction कर देखेंगे.
Yes, ma'am.
एवढा सब 18 19 सब गुड़ा सही था.
19 also same.
Disposal.
Item 19 টা.
ये आना मतलब
Item 19.
number गुड़ा. Yes.
Item 20.
Your lordship, I'm seeking apology. Item number 16, I have said we have received the para wise. So there is a mistake. I have stated we have received the para wise, but we haven't received the para wise, your lordship.
You haven't received.
No, your lordship. There is a mistake by me.
Okay. So you receive the para-wise comment and prepare your count.
There's a miscommunication. My lord, actually the writ petition just now in the last week only we have received on 27.
No, she said that is how you have mentioned.
She was
So we are mentioning in the process of receiving, we are just modulating it. So you item number 16 na. So you para-wise comment received in the process of receiving para-wise comment and thereafter the counter affidavit will be prepared and will be filed. Matter will be listed. It is come in 23rd.
I will inform the.
Just inform that the date has been changed to 16 to 23rd. Yes.
Item 20.
Your representation is annexure
6, madam.
6 you want to dispose. Annexure 6 to be disposed. All right.
Item 21. Item 22. Item 23.
Mr.
Lord, I beg to appear, my lord. Lord, can your lordships hear me, my lord? I appear on behalf of the petitioner, my lord, in this matter. Yes, my lord, this is a matter your lordship would have seen, my lord, pertains to acquisition, my lord, for setting up a Vedanta University, my lord. This was challenged, my lord, before this honorable court in a PIL, my lord. And this honorable court was pleased to, my lord, strike down the land acquisition proceedings, my lord. On the anvil, my lord, that certain statutory provisions had not been complied with. The matter was then taken up by us, my lord, before the Honorable Supreme Court. The Supreme Court has also affirmed the judgment of this Honorable Court, my lord. We place both the judgment of the High Court as well as this Honorable Court on record, my lord. Now, my lord, what has triggered the present, we have actually filed a review petition, my lord, before the Honorable Supreme Court, which is pending. Now, my lord, the review petition has not been dealt with at this point in time, my lord. It hasn't come up for hearing, my lord, before the chambers, my lord. But what has transpired now is that certain decisions have been taken, my lord. There's also a PIL which has been recently filed, my lord, where notice is issued for a direction to the state government to, my lord, act upon the judgment of this honorable court, my lord. Pursuant thereto, my lord, certain decisions have been taken, which we have, my lord, now impugned, my lord. By which, my lord, what happened was under the land acquisition, my lord, the award was passed and possession of about 3,300 acres was actually handed over to us. And we had actually also paid, my lord, or disbursed about 70 crores compensation. This is way back in 2009, my lord. Now, with the result, my lord, if the judgment is to be implemented, obviously possession will have to be restored and, my lord, monies will have to be refunded to us, my lord. But since we have, my lord, filed a review petition, which may be listed, my lord, maybe next month, my lord, and we will also take, my lord, steps to have it lifted. We are only saying, my lord, till such time my review is decided, my lord, the state may not precipitate the matter, my lord, and hold their hands, my lord, because if, my lord, today if possession is taken from us and land is restored, my lord, if my review is allowed, my lord, it will be very difficult to unscramble a scrambled egg. So my humble request is only, my lord, this. There is a PIL pending, which I have annexed, my lord, at page 589, where this honorable court has issued, my lord, a notice on 28th August 2024, page 737. If your lordship so pleases, my lord, this writ petition can be tagged along with this. But the state may, my lord, my respectful submission is, stay its hands, my lord, till such time, my lord, my review, which is pending before the Supreme Court, my lord, is decided. That's my respectful, my lord, submission for your lordship's consideration.
What is the petition number, counsel?
My lord, I'm sorry, my lord, the PIL, my lord, is at page 589. The order of this court is at page 737.
No, review petition. Review
petition, my lord, is at page 306, my lord. I've annexed a copy of the review petition, and I've mentioned at, my lord, page 38 of my grounds also, my lord. This review, I'll just point out, my lord, page 38 we mentioned. Petition number. My lord, the number is given at page, my lord, 38, ground H. Ground H, page 38. I mentioned two matters are pending, my lord, two review petitions. I mentioned the numbers also.
Which one, ground number?
Ground H, my lord, H for Holland, page 38.
Yes.
For that, the opposite parties have failed to take into consideration the fact that there are pending litigations before this honorable court and so, which has been filed by social worker as a public interest litigation. Two, before the Supreme Court in review petition 1165-67 of 2023 by the petitioner seeking review of the judgment dated 12th April 23 passed in civil appeal so. And three, review petition filed by other affected parties seeking review of the Supreme Court judgment of 12th April. My lord, so two review petitions are pending, my lord, before the Honorable Supreme Court, my lord. These are the numbers, my lord. One at our instance, my lord.
So, what further you want from us at this stage?
I'm only saying, my lord, the state may hold its hands, my lord, till such time, my lord, review is decided. That's all, my lord, because otherwise it will create an anomalous situation, my lord. in the event, my lord, we get some relief from the Supreme Court, it will be very difficult, my lord, if possession is restored to the land losers, my lord. And the possession was handed over to us
Mr.
sometime
Mehta,
in
but the
2009.
whole thing is that the entire process of acquisition has been nullified, and it has also been confirmed by the Supreme Court. At this stage, how this court will hold it? Have you
I'm
filed
great, my lord.
interim petition before this court?
My lord, I appreciate what your lordship is saying. That's why I started by saying, my lord, the acquisition challenge has succeeded before this honorable court and also before the Supreme Court. Your lordship is absolutely right.
So
I
is
can't
there any petition pending, interim petition pending before the Supreme Court, which has
My
not
lord,
been taken up?
my lord, review petition. I have, my lord, also spoken to the instructing advocates, my lord. I've told them, my lord, they should take steps to immediately have it listed, my lord. I'm only requesting, my lord, for a short time, if your lordship could consider. The state may make a statement, my lord, even that will be enough, that they will stay their hands for some time, my lord. And we will try and, my lord, get our review petition listed.
So you obtain the status of the.
I will obtain the status report. But any
be-
order,
because
if any interim
we
order,
are not passing any interim order. But by the way, if the London Council also prays for the review petition so that it can be taken up at an earliest in the Supreme Court. So you also just
my lord, I will take it.
Okay.
My London friend, I am requesting my London friend to submit a furnish a copy of the writ application.
Of the writ petition.
My lord.
All right. Give him a
Yes,
copy.
also.
Lord, give a copy. I hope, my lord, your lordship may.
Yes, yes.
If your lordship pleases, my lord, record my friend's statement. That should be good enough, my lord.
This writ petition is being filed by Anil Agrawal Foundation, a company registered under Section 25 of the Companies Act 1956 for a direction to declare the later number so dated 8/10/2024, the minutes of the meeting dated so, the later dated so, annexure 1 to 4 are ultra virus Article 14 of the Constitution of India, being discriminatory, arbitrary, and in contravention of the principles of natural justice. And to issue necessary writs direction for quashing the latest dated so, being violative of Article 14 of the Constitution of India and contravention of principle of natural justice. Referring to paragraph, page number 38, paragraph number H of the writ petition, the Land Council submits that two review petitions are now sub judice before the Honorable Supreme Court in RPC number 1165-67/2023, which was filed by the petitioner seeking the review of the judgment dated 12/4/2023, passed in civil appeal number 1144-1146 of 2011, and review petition filed by the other affected parties seeking review of the judgment dated 12/4/2023, passed in the said civil appeal. The Land Council submits that in the meantime, you will place for the review petitions or early hearing before the Honorable Supreme Court. Let the Land Council for the state obtain the status of the proceeding. Matter be listed a week after. In the meantime, a copy of the writ petition be served on the Land Council for the state. That's all. Let him obtain the status.
May I request if your lordship could consider listing it sometime in January, my lord, so that in the meanwhile, because if my lord, vacations.
All right. January 2nd week it will come. Okay. Yeah.
My lord, a statement of the government council, my lord, I hope. My lord,
Yes,
we are recording it that he will obtain the status.
Mr. Dhruv Mehta, Senior.
Yes, my lord.
Yes. Yes.
Item 24.
Please, my lord. My lord, the petitioner paid this on report to delete the interest 2023 to 2024. Actual release of the I have filed the recommendation and extra 3, my lord.
Representation.
Yes.
Item 25.
May I please, your lordship. Here, my lord, I have obtained a loan for housing loan from the bank, my lord. The opposite party number 2, my lord. Sorry, my lord. Open number 1, my lord. In the now, the bank has initiated a case against the petitioner under section 19, my lord, of the debt recovery. Sorry, my.
So 17.1 is pending.
My lord, 17.1 filed by the present petitioner.
Yeah.
That is pending.
Yes.
Thereafter, the bank initiated a case under section 19 under the recovery of debt due to Bank and Financial Institution
Yes.
Act, my lord. In the meantime, the bank also initiated a case against the petitioner under section 14 before the collector for recovery of possession. So, my humble submission before your lordship, when the bank has instituted a case under section 19 of recovery of dues, my lord, at the same time he instituted a
So the proceeding is subjudiced before the DRT.
DRT, my lord.
Whatever application you want to file, you file there. Why have you filed another writ petition here?
My lord, because my
forum is in session of adjudicating your grievance. If any problem you are facing, do you file an interim application? Can is very competent to give the relief. Why have you again approached this court? Look, this writ petition has been filed by the petitioner Sadat Kumar Jena with a prayer for a direction to the opposite party number 1, authorized officer Bank of India, Baripada Zone, not to proceed under section 14 of the Surface Act against the petitioner. Where have you stated that your application, which paragraph?
my lord, that is annex. Sorry, my lord. Sorry.
What was the paragraph, relevant
My lord.
paragraph of the writ petition? Which order you are challenging and which application is pending before the
My lord, paragraph 9, my lord. My application. My application is paragraph 9.
The learned counsel for the petitioner drew the attention of this court to paragraph 9 of the writ petition and stated that the petitioner has filed an application under section 17 of the Surface Act before the London DRT cutter against the bank, and the same has been registered as a DY number 761 of 2024. That means it is with defect. Defect has not.
There is a limitation. So,
whatever.
My
but to file that delay condonation application.
My
And in the said case, notice has been issued the bank for appearance and to file show cause, and the bank has already appeared in the case. The London Council submits that while the matter stood thus, the petitioner received a summons in OA case number 441 of 2024 filed by the Bank of India in the DRT cutter, which was filed under subsection 4 of section 19 of which act?
My lord, that they have not mentioned, but it should be recovery of debt due to Bank and Financial Institution Act.
I got the DRT procedure rule 1 for uninsured proceeding. It is the contention of the Land Council for the petitioner that when the bank has filed an application for the before the DRT for realization of the loan amount and that application is still pending, the bank should not have filed an application under section 14 of the Surface Act before the collector further for taking possession of the secured mortgage property which is arbitrary and illegal. stop. Since the London Debt Tribunal DRT is is in session of entry two original applications, and the prayer sought for in this writ petition can be taken care of by the DRT. We are not inclined to interfere with the order with the we are not inclined to accept the prayer made in this application, giving liberty to the petitioner to approve the law in accordance with law, according to the writ petition.
Oh, bless it.
Kindly, our name.
Yes.
Item 26.
May I please, Your Lordship? I'm challenging the e-auction notice and sale certificate issued in favor of the OP number 3 million when the petitioner is going to settle ready to settle the account under OTS, and he has been asked to prepare a draft, and he already prepared a draft of 16 lakh.
Sale certificate টা কেউ 9 to 24.
But no registration till date.
With a prayer for passing the notification of the sale notice for them, dated 2/1/2024. So also the sale certificate issued, sale certificate dated 9/2/2024, issued in favor of opposite party number 3, Ram Niranjan in view of the Patna Motors case, since alternative remedy is available with the they are not inclined to interfere with the same, and according to the petition which is forward. Yes.
Liberty to file with them.
That is there.
Oh, bless me.
Number item number would have
Yes.
24, 25 car.
Yes. Oh, bless.
Item 27.
Passover item. Passover item.
So 25.
Item 13.
1-3.
Yes.
Passover item number 13.
I may please, Your Lords. Your my lord, I have challenged the order of the collector under annexure E, my lord, by which the petitioner is a displaced person, my lord. His land is being taken for Khordha Bolangir broad gauge rail link, my lord. The petitioner, being a displaced person, was declared as such by the competent authority, my lord. Thereafter, they asked for payment of compensation under RR scheme. Since the same not being paid, he approached this honorable court, and this honorable court directed the petitioner to approach the competent authority and consider his representation. Thereafter, by the order under annexure 5, your lords may kindly turn to, the petitioner has been directed for release of compensation under RR scheme. But in the said order, your lordship may turn to the last paragraph at page 27. The compensation towards land and structures to be paid after disposal of title appeal 25/2000 pending in the court of discharge board. The previous paragraph was also important. Your lordship may kindly see. In view of the fact mentioned above, I am of the opinion that it will not be improper to release the amount sanctioned under rehabilitation and resettlement scheme in favor of the petitioners and their mother. Hence, the LA Collector Khordha Road Balangir New BG Rail Link Project both is directed to disperse the amount sanctioned under RR scheme to the petitioners Sri Lingaraj Deuri, Chapadhari Deuri and their mother Gurubari Deuri. The compensation towards land and structure to be paid after disposal of title appeal number 25/2000. But my humble submission is, though I have been released the compensation RR scheme due to non-payment of the compensation towards structure of the house structure and the land, the parent petitioner has been unable to construct a house to
She
What is the
with
title appeal?
title appeal, as far as title appeal is concerned, that has nothing to do with this the land, my lord. Title appeal is preferred against the order passed in a suit for partition. In the partition suit was decreed, and the being partitioned, the one of the shareholders of the petitioner's father, my lord Aholya Dehuri, this land has been separately recorded in their name. I have also annexed 7.
For the parties in that title
In the appeal, my lord, Basanto Dehuri and his relations were party.
You have not made them party.
It was not required because the partition suit being allowed, the land in question.
Being allowed, that is also
Appeal is there.
Appeal is pending not in respect of that property, my lord. Your lordship.
What is the petition suit order? Have you annexed it?
No, my lord. Annexed 7, your lordship.
Suit has been filed. Have you annexed the claim?
My lord,
the orders passed, it is 2000 title appeal, and we do not know what is the status of the title appeal.
Your lordship may kindly turn to Annex 7. That is the ROR prepared on the basis of the result of the title suit.
You see, you are not making a party to the persons who have preferred title appeal. If you say that is nothing to do with this your entitlement to pay the structure value of it, then we have to be satisfied that the land which is the subject matter of that petition suit or the title appeal is nothing to do with this one. For that, you have to file the petition suit deeply the other thing, title appeal claim.
My humble submission is, after the partition suit is disposed of, the
counsel, we are nothing. You are not filing anything.
Annex 7 is the ROR, my lord. That has been prepared on the basis of the
Annex 7 is the ROR concerning your case.
Not, yes, my lord.
Yes,
it is
what is the plaint about? What for the partition was? You were a member in the, you were a party in the partition suit.
Well,
and the case has gone in your favor. Might be.
Not in my favor. I have preferred the appeal. It has not gone in my favor.
Then you have preferred the appeal also.
So far as this property is concerned, that
how can we know?
That is not in the share of the.
Unless we compare it, you file it, we'll see.
You have to see the schedule of land. The counsel, you are making an oral submission that is nothing to do with this.
All right.
You have to satisfy this court.
My lord.
That see the
schedule of property in that suit and this.
My lord,
that's all.
My lord, what I have tried to submit, my lord.
Please bring it otherwise.
Without document, we can't see.
That is why I have Annex 7. The
no, Annex 7 is one part. No.
That is recorded in the name of other co-sharer.
Might be.
I will submit, my lord. If your lordship permit, I will file the.
That order we are passing, just file it. Challenging the order dated 17/8/2023, passed by the collector court in refusing disbursement of the compensation towards land and structure acquired under KRB new PG rail link project in favor of the petitioner. With a further prayer for a direction to relieve the compensation towards the land and structure in favor of the petitioner. Referring to the improved order, the Land Counsel for the petitioner submitted that though the collector board opposite party number 2 has been pleased to hold that it will not be improper to release the amount sanctioned under rehabilitation and resettlement scheme in favor of the petitioners and their mother. Hence, LA Collector Khurda Road, Palangir, new busy rail link project board be directed to disburse the amount sanctioned under RR scheme to the petitioners Lingaraj Dehuri, Chapadhari Dehuri, and their mother Guruvari Dehuri, who are the 3 petitioners in this writ petition. But in the end, it is stated that the compensation towards land and structure to be paid after disposal of the title appeal number 25 of 2000 pending in the Court of Reliance District Judge Court. And counsel for the petitioner submits that the said title appeal number 25 of 2000 has nothing to do with the disbursement of the amount compensation amount towards land and structure to the petitioners. When we made a query, it is submitted by the land counsel for the petitioner that the said title suit is pending against the order.
Title suit is disposed of. Title suit is disposed.
No,
Title appeal is
pending.
Sorry, title appeal is pending against the order passed in the partition suit, and which is filed by the petitioner, and the in the appellant and the petitioners are the appellant in the title appeal. To know whether the lands which are
Subject matter.
which are the subject matter in the partition suit, so also in the title appeal, whether has any not any link with this present proceeding, let the land counsel for the petitioners file the quickly passed in the the partition suit. The number
FDCS number that is reflected in the Annexure 7, Bala.
Copy of the grant, copy of the grant, order passed in the decree passed in the
TS number is there.
TS number.
I got TS number that is there in the rejection order.
Title suit number.
Title suit number. My lord, title suit number. Yeah.
6.
Title suit title civil suit number 31 of 1994.
CS
It up page 25 of the impugned order.
25 page 1. CS 31 of 94.
1994 in the Court of Civil Judge, second para below the table model. What's the
civil suit number 31 of 1994 in the Court of Civil Judge Senior Division Court. Decree passed in the said civil suit. Also, the appeal memo in title appeal number 25 of 1000. The next step. Yes.
That's not fixed date.
This is the counsel.
Item 17.
Item 17. One more defect is there, my lord. What has happened? The index was wrong. Accordingly, wrong annexure was filed, although it is reflected in the body of the writ petition and it is under challenge. That order was.
Trying to file the
Yes, I have filed the index. Correct index I have already filed, but inadvertently that according to that previous index, wrong annexure was filed. Although it is reflected in the body of the. My lord, I have already filed. Your lordship may kindly accept it so that otherwise they will not. Annexure 8.
Annexure 8
applies to the prayer. The prayer is
representation.
Prayer sangre kon achi defect remove.
Representation disposal.
Order under Annexure 8.
Your lordship.
Dated 26/7/2022 shall not be quashed, my lord.
Yes.
But Annexure 8 is a representation.
ସେଇଟା ହିଁ କହୁଛି ସେଇଟା ହିଁ କହୁଛି ତମେ କାହିଁ ଅବିକାଠୁ ଉଠିକି ଠିଆ ହେଇକି କାହିଁ ପାଟି କରୁଛ ବୁଝିପାରୁନି ଆଗ ତୁରିଆ ଉଠିକି ପାଟି ଚିଲୁଛୁ Annexure 8 ଲେଖା ହେଇଛି ଆଜ୍ଞା ବଡିରେ ବି ଲେଖା ହେଇଛି ହଁ Annexure 8 ମଧ୍ୟ ମୁଁ ଦେଇ ସାରିଛି along with the index ପୁରୁଣା annexure ଯୋଉ Annexure 8 that may be ignored and my Annexure 8 may kindly be accepted, which was filed along with the index.
That means the document in page number 45
Yes,
be,
that is to
be
be.
accepted as annexure 8
Yes.
in place of the annexure that you have already mentioned as 8.
Yes, that may be. Obliged manner. I have filed also. Your Lordship may kindly see that.
With Sujata General and Counsel appearing for the
हमने नौ कौन स्टार्टिंग
submission that as per the expert dated 26/11/2022, he has filed the index corrected index, and the same will be accepted. And annexure 8 is the photocopy of the order dated 26/7/2022, passed by the collector of internal, which she has also annexed with the index, and the same will be substituted in the repetition in case of
annexure 8,
which is the representation before the district collector of Telangana and district magistrate Telangana. The Madam Counsel for the state has no objection. Accordingly, the legislature shall do the needful in replacing the annexure into the petition by the annexure 8, which is filed by the Madam Counsel for the petitioner, along with the correct endeavor. The page numbers shall be mentioned correctly. Page number to mention করছেন
हाँ 45 to 49 হবে
It has already received copy of the warrant. Matter will be looked next week. Next week as well.
না Your Lordship may
Keep it on.
keep it to 19th.
If this matters on 19th December 2020.
Obliged.
Item 21.
May I please, Your Lordship. Here in this case, Your Lordship, the petitioner availed a diary loan of rupees 4,75,000. So for purchase of 10 cows, but within 1 year, the sanction of the loans, all the cows dead since you could not be able to. 13 for notice has already been sent. We have already principal amount deposited. At least to know till then, Your Lordship, no question.
Item number 20.
May I please, Lordship? The petitioner availed loan from the opposite bank in the year 2022 for construction of dwelling house. Accordingly, the opposite party bank has issued a 9-1 notice for the purpose of sale the same mortgage property. The petitioner also ventilated his grievance by filing the representation, also directing the opposite party bank to take a decision on the sale. Sale note.
This matter auction is failed.
Auction
due to
failed.
non-participation of the bidders.
Auction was failed.
Auction was failed due to non-participation of the bidders.
Consider representation.
Below they have to pay some upfront amount.
Upfront amount
Within stipulated time.
The petition has been filed. Challenging the sale notice under annexure 1, which is dated 9/10/2022. Also appealing for the Union Bank of India submits that the auction sale has become unsuccessful, and if the petitioner approaches the bank is ready and willing to negotiate with the petitioner. And counsel for the petitioner submits that a representation under annexure 2 is already pending with the bank, and the same may be considered. And counsel for the bank submits that if any upfront amount as for negotiation is paid within in stipulated time, the bank may consider the same in view of the submission made by the counsel for the respective parties without expressing any opinion on the merits of the representation. The bank is consider the representation of the and if necessary personal hearings or the proposal observation, the petition is yes.
Item 27.
Yeah, third zero.
The council now.
Let's refer for third bench, larger bench.
It's number 338 of 1998 has been filed challenging the judgment and decree dated 25/8/1998 and 9/9/1988, respectively passed by the first additional district judge Najam in money appeal number 8/18 bracket 5/87 CBC. The matter was paid to single bench of this court. The matter was directed to the placed for order dated on 20/3/2017. The matter was directed to the placed for order Chief Justice for constitution of larger bench to answer following reference. But at one of the board whether the municipality can sue or be sued without being represented by any person. Question mark. So non-affairs body land this man. We want to the case.
Item 28.
For the
Municipality.
Council summons, we adjourn to next.
Previous
Paraspur municipality.
Parampur.
It was this one. नहीं এটা রেফার ହେଲା ପରେ ଆଉ ତାଙ୍କୁ ତ ଯାଇନି ନୋଟିସ୍। Actually, ରେଫାର ହେଲା ରେଜିଷ୍ଟ୍ରି ଯିବା କଥା ନୁହେଁ। ଏଇ ପଦ୍ଧତି no one telling me or Parampur municipality that obviously second appeal
with all the annexures sent by the registered judicial. The district judge particularly should not be district judge Hon'Ble.
To be served upon them.
Item 28.
Maybe adjourn to next.
Work for the
Advocate for summons, right?
petitioner.
Yeah,
You want adjournment?
my lord.
Which date you want?
Next week, my lord.
Next week. A mention is made on behalf of the petitioner for adjournment next week. This matter will come from 9 December 2020.
Item 29.
Your lordship, the petitioner has filed the same appeal to restore the writ application number 19,623 by 15, which was dismissed for default. This matter was listed on 16th August 2022. But on that day, the counsel was suffering from loose motion, so he could not attend the court. So the matter was dismissed for default. So we have filed this.
This in the WPC notice has already been issued or it was not issued.
Already issued.
So now in the CMAPL notice has been issued. CMAPL level. The CMAPL has been filed. The prayer for restoration of WP PIL number 19623 of 2015. And the order of dismissal dated 6/8/2020. Set aside the order of dismissal dated on. Issue notice to the opposite parties. The land counsel for the state accepts notice
1 and 2.
on behalf of opposite party number 1 and 2. That extra copy of the CMAPL we served on the land counsel for the district. So far as private opposite party number 3 is concerned, the requires for issuance of notice on opposite party number 3 be filed.
Your lordship, we have filed another I number 404 by 24. During pendency of the litigation, the OP number 3 sold his industrial unit to HIL Limited.
All right. Let it.
First appeal and the matter is placed to be read. Dismissed.
Item 30.
Please, my lords. So this is the item where my lords had asked the registry to give a note on the delay concerned.
Yeah, given the
My lords, you also can see what is the that is in flag G.
GIC.
Flag G, what is that?
Yes, my lords. I flag G.
Flag G.
My lords.
Yes.
Deputy Judicial Flag G.
during calculation of allocation, may be noted that portion of the council was directed for showing the defect and non-parties from the allocation in the calculated.
Right. So pursuant to the order dated such and such, delay of 23 days in filing same appeal instead of 680.
I was verifying my lord brief. Nothing was given any explanation at all. Only said that as per the we have calculated.
Perhaps they're not aware.
They
The,
must-
the decision that has been cited by my learned senior.
First of all, let him
No,
give
no.
a clarification. Let the office give the clarification because the lordship have asked a particular question.
Okay. We are passing it over. Let him come and we'll take it.
Item 31.
This repetition is directed in the order of the appellate debts recovery appellate tribunal, who refused to condone the delay. Only on that ground, the writ petition has been filed. When this matter was taken up here, the first instance, this honorable court wanted the matter to be resolved here at this stage and wanted me to include all the persons, the loanee and the subsequent persons to whom the interest has flowed, to make them parties. Accordingly, this application was filed. So, if your lordship wants to hear it on merits, the entire case, this amendment was.
Proceeding is sub judice before a competent forum.
No, it's not sub judice because he has rejected the appeal on the ground of limitation.
Okay, that order you have challenged.
That I have challenged in the writ petition.
Okay, now there is some delay or what? Only this IE has been filed for.
The IA has been filed for addition of parties.
Amendment. So, okay, somebody took time to file.
The bank had taken time to file objection. In fact, twice they had taken time.
M.K. Mahapatra.
Twice they had taken time.
What is your prayer for amendment?
Prayer have just sought to implead these persons as parties and take some grounds for adjudication of the case itself. Final adjudication on merits.
Well, appealing earlier.
Yes, twice he has taken time before your lordship. Last order also your lordship is. 8/11, 13/11, 25/11.
We in the last time also you said that the copy of the objection we saw on the Land Council for the petitioner. That order we passed. We're just passing it over the council. Can we engage in some other court? So let us pass it.
This addition will not be necessary if your lordship takes it up on merit.
Just hearing and pass.
As you
Item 32.
Please, my lord, it's not a securitization matter, my lord. It is only for refund of the excess deposit made. Securitization matter has already been closed. Therefore, the office pointed out that for filing of the second copy is not necessary for us. The claim only starts after answer 8 and 9. Securitization matter is closed. Notice was. My the loan was taken. The petitioner before your lordship is the guarantor. Surfacing notice was issued. Pursuant to the surfacing notice, he has made some deposits. Guarantor has made some deposit. In the meantime, the loanee has settled the account. And it was now the non-due certificate was also issued. Thereafter, she made an application for refund of the deposit. It was not adjusted. The loanee's amount was paid and the loan was clear. So now she filed an application before the bank authority to refund the amount. That was not responded to. That is the seeking for a direction for payment of.
So legal notice has been issued, that should be taken.
Surface was earlier issued, it was closed.
Which is that legal notice?
Legal notice is answer 9 manner.
So, who is the opposite party here?
State Bank of India. Manner.
I think Mr. Sahoo can.
No, State Bank.
State Bank of India. Mr. Mahapatra. So, now let's see about disclosure for the ଦେଇଛନ୍ତି
Legal notice.
କନସିଡର କରିକି ତାଙ୍କର ରେଜଲ୍ଟ ଜଣେଇଦେବେ ଆଉ ଏତିକି କଥା ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଆପଣଙ୍କୁ କାଲି ରଖିବା ଆପଣ appeal କରିବେ ନେବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଉ ତାର ପ୍ୟାନେଲ ଥିବ ନା ଆପଣ ପ୍ୟାନେଲ ରଖିଛନ୍ତି ତ simple things are that is to be ଆପଣ मनोज कुमार महापात्र Mr. Manoj Kumar Mahapatra, who is the current counsel of the State Bank of India, submits that the matter may be taken up day after tomorrow, so that he will obtain interception whether will appear for the opposite parties or not. Output of this matter on December 2024, indicating the name of Mr. Counsel in the process.
Item 33.
May I please, Lord, Siana VC Miloda, on behalf of Mr. P.K. Nayak. Item 33, two items are there, Miloda. The first one wrongly has been filed and after the Central Administrative Tribunal. Two cases are there in item 33. First case I will file after the Central Administrative Tribunal because that is filed directly.
There are two applications he wants to withdraw. The first application is filed an interim application.
No, you
First one 9503. I will approach the if my
no, sir. Item filed by the Union of India, and he has to file rejoinder also.
What about the first one?
First one wrongly it has been filed here for a retirement claim for retirement benefits.
So item number 33, WPC number 9503 of 24.
Yes, my lord.
Is filed by Satyananda Naik. You want to withdraw?
Yes, my lord. Yes, my lord. I am for the petitioner.
The Guardian Council for the petitioner seeks permission to withdraw the petition. That is WPC number first part. This put of a withdraw. Second, WPC number. आधे आपण काउंटर फाइल कर सारलेनी
तो रिजल्टर फाइल नेक्स्ट टाइम हेल्प करें
रिजल्टर फाइल करिवे आपण
रिजल्टर पर फाइल है सर
नेक्स्ट
टाइम
WPC number 25115 of 23 the Mr. Bhoptal and Counsel appeal for the Union of India along with Mr. Pari and such submits that counter affidavit has already been received and Union of India intends to file the resultant affidavit and for such purpose to extend this matter in pre-commencement from present.
May I pray, my lord, some small prayer, my lord? I am retired in 2014. Now 2024, some retirement dues are there. Only that is the dispute, my lord, before my lordship. So pray for some short date or in the supplementary list, my lord. You subject to my lordship convenience.
ପରେ ମାନେ ଆସି 23 ତାରିଖ ତ 23 ତାରିଖ ଆସିପାରିବନି ତ ଏଟା ଜାନୁଆରୀ 2nd ୱିକରେ ଆସିବ ହେଲା
Oblige. मतलब सब फिक्स डेट सदा जदरे अदरवाइज आई वुड नॉट हैव अ प्रेशराइज माय लॉर्डशिप
डेट फिक्स अप हबो संध्या बेले देखि देबे आपण हाई कोर्ट वेबसाइट
oblige
प्लीज
Item 34.
My lords, humbly pray for modification of order dated
23/10/2024. It is CMAPL 647 of 2020. Though the dear judicial has submitted the report, which is at flag G, but we find that that is not in consonance with the order dated 4/11/2024. Let a fresh report be submitted, keeping in view the observation made in the said order. Matter be listed there table. Along with on the matter is on the matter. But tonight we are just coming within 2 minutes.
Item number 34. My lords, humbly pray for modification of order dated 23-10-2024.
What modification you want?
I have applied for the certified copy, but the copy section did not give the certified copy, saying that there is a mismatch in order and the uh, cost item. Cost item.
କଣ ହେଇଛି ସେଇଟା ବେଣୁ ପ୍ରଧାନ ଅଫିସ ତାହେଲେ କଣ୍ଟାକ୍ଟ କରୁଛି
Venu Pradhan versus State of Odisha. कौन mismatch है ना?
Venu Pradhan versus State of Odisha, that cost title is all right?
Yes, yes. My lords, that is all right.
Then?
कौन mismatch कौन?
I don't know, but
Because he
the
doesn't get, he have not
copy
received
section did not give that.
The office should point out.
Where have you stated that?
Yes, in IA, at page number 4, paragraph number 4.
Provide the certified copy that there is a mismatch in the above order and the cost title.
Kadaj.
Mismatch in the above order में 23/10/2024 23/10/2024 the Venu Pradhan 2551 sponsor by the opposite party. A petitioner with the Venu Pradhan State of Odisha रहेला number ठीक रहेला mismatch कौन है?
They did not provide the copy. Now already 4 weeks time also elapsed.
All right, 15 IN number 15586 of 2024. This is an application filed for modification of the order dated 23/10/2024. Stop. The reason has been assigned that the petitioner applied for urgent certified copy, but the copy section didn't provide the certified copy as per rules, orally citing that there is a mismatch in the order dated 23/10/2024 and the post title. Let a report be called for from the registered judicial as to why the certified copy applied for by the petitioner, by the land counsel for the petition has not been furnished to him. Matter will be placed next week.
I pray to tag another matter, similar matter, disposed of 24 read petition number 24738.
सेठी मध्य से आई जी कॉपी
Same similar.
अच्छा
read petition number.
Just a minute. Land and counsel for the petitioner submits that similar order, similar information has also been given to the to him when he applied for the certified copy in WPC number
24738 of 2024. 24738 with IN number
of 2024.
24.
Okay.
IN number 15587.
For which he has filed an interim application by IN number
15587 of
15587 of 2024. In the said case also, the deputy registrar shall place registered judicial shall place a report list this matter along with say your WPC number. Next week.
Obliged.
Item number 35.
My lord, in item 35, this was with regard to the acquisition of the structure for which valuation was made. Considering that I have made a reprehension, your lordship was pleased to direct the opposite party number, my lord, 3 to consider my reprehension and if necessary to provide personal hearing. Now some other order has been reflected in the order sheet. That is why it has come up. Which is not.
Correct order ଟା ଅଛି ତାକୁ reflect correct order available ଅଛି ନା ଆଉ ଗୋଟେ କୋଉ order ଆଣିକି ପୁରେଇ ଦେଇଛନ୍ତି the report of the office report dated so and so. Order dated 18/11/2024. Passed in this case inadvertently, which has been inadvertently shown in this is recalled, and the corrected order will be reflected. है ना? Just searching for the pattern. So immediately say order to recall karibe. That the same also be carried out in the official website, High Court of Orissa. है ना?
May I pray for urgent copy again, my lord?
Lordship, in item 36, IN number 16/2024 may kindly not be fixed.
IN number 16016 of 2024. This is an application for modification of the order dated to Counsel, and Counsel for the petitioner does not want to place this interim application accordingly.
Our presence may kindly refer.
Sahoo
They have taken a order from the civil court.
Interim order for the Union of Bank of India is present
Against this schedule.
Next.
Obliged.
Item number 37.
I may please your lordship, I put a virtual one. You can look at page 9. Lordship may look at page 9, my lord. The government created different posts under the family judge Katta. I'm sorry, Khorda. Serial number 7, let's see, we can look at serial number 7. Post of typist was created. Then your lordship kindly see page 11.
Mr. Mishra.
Yes, my lord.
I think it is for final disposal.
Everything is ready, my lord. For last some years, I have
Why don't you come to the court and argue the matter?
My lord, my humble submission would be that is a clear the family court Khurda.
No, he couldn't get probably.
We just want you to remain present in court and argue the matter.
Tomorrow, day after, any date, my lord.
Any date.
Today I'm ill, therefore I'm not able to go.
Are you comfortable day after tomorrow?
Day after tomorrow, my lord. Yes, ma'am.
As prayed for, please this matter on 4th of December 2020.
Item number 38.
As provision, the lordship directed the State Council to submit the copy of I number 578 of 2021, which was regarding the clarification. So, like the copy of that IA.
No, we have given it. We have given it. No? My lord, sir. We have collected it because it was a bulky record, my lords. Some disposal records were also there. We have got it, my lords. My instruction is that we have received the copy. In fact, we have served, but however, there is some miscommunication. I'll serve it.
What is that IA?
IA number 578.
That is not in the second one.
Yes, my lords. That was filed by the state.
Right. So the second W A number, read appeal number 6 of 2020. IA number 578 of 2021. This application has been filed by the state of Orissa for clarification of the order dated 6/3/2020 and for a direction to delete the word generic from the operating portion of the order dated 6/3/2020 passed in WA number 6 of 2020. The London Council for the appellant, who is the appellant submits that the copy of the interim application has not been served the London Council for the state submits that he will supply the copy
in
to
course
the
of
London Council for the appellant during
in course of the day, my lords.
during course of the day. Put up this matter next week for consideration of the interim application, along with WPC number 18973 of 2020. So, we'll hand over during course of the day.
Yes, I'll. Item number 39.
That was ordered for the consideration of the medical arm of the wife of the.
No, last time
Mr.
Mr.
Niranjan
Niranjan Panda
yes.
said that he will argue the matter. So, no, you are fluctuating or what? Sometimes you are saying that Mr. N. Panda will argue. Sometimes you are coming up. Are you not able to make up your mind that who is to argue this matter? Either you argue in person because Mr. N. Panda, as it order sheet goes, that he says that he has been entrusted to argue the matter and he made the submission. Now again you are coming up. Tomorrow again he will come and say that
This matter belongs to your case. You are the affected person. So you want to argue in person. So how the name of Mr. Panda was there?
he said that.
The other day you moved and he had come also.
Have no, you see, we have nothing to do. You either you argue or but
Yes.
there should be some consistency. Today you will say next date if we adjourn, Mr. Niranjan Panda will say come and so either you appear, you are there as the petitioner number one, you can argue there is no problem with her.
This has been going on since January. Lordship, it is 7 May 2024.
Yeah, we have already seen that
Mr.
sometimes
Panda
you
said
say
that,
that my lawyer will argue. Sometimes you are coming up that I will argue. So you must decide that who is to argue the matter. If the counsel is not available today or is held up in some other court, there is no problem. We can take up this matter tomorrow, day after tomorrow. But if you say that no, I will not, this counsel, in spite of the fact that he has filed the power, I will argue the matter. It's all right. Then you argue the matter. Why the counsel would come and say that? What do you say? Today will place the one. Yes, place the one. What you are challenging here? By the way, who is Resma Behra? And who is Mono Ranjita Behra? So you can argue the matter on your behalf, but how can you argue as a for your mother? Has the mother entrusted you? Where is the
Yeah.
has she given authorization to you to argue this matter? No, Mr. Madam, if you are the opposite party petitioner number 2 in this case. If you say that your mother has authorized you in person to argue the matter, there must be some authorization letter. Because the counsel is there, we have to disengage him. We will say that his name shall not be reflected in the cause list. Because in some days he is coming out to argue the matter. So that is why if you say that your mother has entrusted you, please file the authorization letter and also simultaneously will disengage Mr. Niranjan Panda.
Only
The mo-
Sister Lordship, that order is already there on 7th May.
Which
That 7th May to 2024 order, it
7
was
May.
already directed by this court that the name of Mr. Niranjan Panda be deleted from the cause list.
Again, she made a prayer that
That is only for Sister Lordship. 7th May 2024. He appeared in person and said that Mr. Panda wants to withdraw his power and his name may be deleted.
you see again on 29/8/2024, that is order number 21.
Yes.
The petitioner appearing in person submits that she had already engaged counsel to argue the matter on her behalf and the matter may be taken up. So again, she says we cannot prevent her.
No,
The question is that either she argues or any counsel, but there should be some kind of consistency. It's not that today you say that I will argue, tomorrow you say I will engage a counsel. So, and you are not the sole petitioner here. Your mother is there. So, often the authorization letters to argue the matter on our behalf also. We are taking up this matter next week and we are deleting the name of Mr. Niranjan Panda and who is that Ashish Kumar Mishra also from the cause list. No, it is not as if it is the fault of the either London Council for the opposite party or for somebody else. It is so. Matter is there, we are ready to take up, but you are not able to decide that who is to argue the matter. So you want that this matter should remain as such and would come tomorrow, or like this matter tomorrow as prayed for. Okay.
Item 40.
That's it. District person. Yes. I mean, the entire land was almost in Bengali irrigation project. I was wrongly not declared distressed person. I have to fight much and this person to the orders of this own court. They declared me distressed person. For compensation, they paid me in November 21, 2021, 94,000, which is at the rate of 94 rate, my lord. 94 rates. The policy says. No, they have filed the counter affidavit. Yes, and you have received the copy. The copy. So why they have stated done that? They are saying we are whatever we have done, that is right. No, not that way. Please come to the relevant paragraphs. We come to paragraph number 6 of the counter affidavit.
Yes, paragraph 6 and 7.
Please come to that. Please place it.
That in reply to the averments made in paragraph 3, 4, and 5 of the writ petition, it is respectfully submitted that petitioner along with his family was not residing in the aforesaid villages, namely
In the affected village.
That is decided in alleged
Right.
and during the land acquisition, as he was in government service, as he was not enumerated as displaced family and not received the RR benefit under Orissa Rehabilitation Resettlement Regulation of the Project Affected Persons Policy 1994, the petitioner filed WPC number 664/2009, redressing his grievance, disposed of this said WPC WPC number filed order dated 16/3/2027.
କେବେ ହେଇଛି sir? 16/3? 7. All right.
17. With the direction to opposite to reconsider the claim of the petitioner, taking into consideration the recommendation made by him under Annex 2, as well as opinion of the Law Department, Government of Odisha, and the pass necessary orders, as well as take consequential action. Consequently, the opposite of 3, the collector and district magistrate Hon'Ble, by order number 3719, tells that the prayer of the petitioner is found justified and being a displaced person of Bengali irrigation project Samal, he is entitled to rehabilitation assistance as admissible under RR Policy 94. A copy of order dated 3719, that is annexed by law. In paragraph 7, that in reply to averments made in paragraph 6, 7, and 8 of the writ petition, it is respectfully submitted that the petitioner has been provided benefit under RR with compensation mentioned in RR Policy 94. It is not as per policy matter. Have provided policy and policy. That in reply to the averments made in paragraph 9 of the writ petition, it is respectfully submitted that pursuant to the order passed by the Honorable High Court in WPC number 664/2009, the collector Hon'Ble extended the rehabilitation assistance as admissible under RR Policy 94. Accordingly, prepare calculation matrix for rehabilitation assistance RR Policy 94 as for the latest dates fixed by the government. The details calculation of matrix includes components like cash in grant of lieu of homestead land 20 decimals, cash in lieu of agriculture land 4 acres on irrigated land, cost of house building assistance, transportation charges, and maintenance allowances. I am entitled to 20 decimals of homestead and 4 acres of unirrigated land. That in reply to the averments made in paragraph 10 and 11 of the writ petition, it is respectfully submitted that the petitioner has been provided with the cash in lieu of land for homestead and homestead land for 20 decimals and cash land in lieu of agricultural lands for unirrigated land 4 acres 0 decimals, while calculating the matrix for rehabilitation assistance, keeping entitlement for all aspects RR components, every individual houses of small village as equally in Ayat law. That in reply to the averments made in paragraphs 12, 13, and 14 of the writ petition, it is expected to submit that there is nothing wrong in calculation of RR matrix as per the latest resolution dated 30th September 2004. For this matter. Clause 10 of the RR policy.
No, so you are telling that the amount which has been paid to you is not in accordance with the policy. They are stating that it is according to the uh, latest market rate, it has been calculated and payment has been made. So now the dispute arises. How can this court would decide that whether the amount is proper or not?
They are not giving the calculation sheet, madam. They are not providing the calculation.
But their reply is this, and they have annexed some documents also. It's not that plain and simple they have filed.
They have given the document, my lord.
Yes.
The document only they have said the total rate, the calculation. They have not given the calculation. They are giving the total amount, my lord.
No, let us say that they are what they have stated that it is correct, and this is the basis on which we have calculated. Now, how can we adjudicate all those matters?
Only one point, my lord. And I'm giving the note of the clause 10 of the rule, my lord, for the policy. Cash grant may be rupees 20,000 per acre of irrigated land and homestead land of rupees 10,000 per acre of unirrigated land. The base price, this is the base price being 94. There may be a provision for escalation every year as per official index prescribed by the government and revision of the amount of grant in every 4 years. This includes cost of reclamation.
ঠিক ଅଛି ସେମାନେ କହୁଛନ୍ତି ଏଇ ଯୋଉ ପଲିସି ଅନୁଯାୟୀ ଆମେ ଦେଇ ଦେଇଛୁ
ଏଇ
ଦେଇଛୁ ଆମ ଏଇଟା ହଉଛି ତାର ଇଏ ଭାଉଚର ଏଇଟା ତ ଆପଣ କହୁଛନ୍ତି ନାଇଁ ସେ ପଲିସି ଅନୁଯାୟୀ ସେଟା କାଲକୁଲେସନ ହେଇନି କାଲକୁଲେସନ ଏମିତି ହବ ସେମିତି ହବ ଆମେ ସେଗୁଡା ରିପୋର୍ଟ ରେ କେମିତି ଦେଖିବୁ
as per the policy of the present price index is some calculation correct. ସେଇଟା ସେତିକି ଖାଲି କରିଛନ୍ତି ଦେଖେଇ calculation present price index as per policy. As per the
present price index with
that we have admittedly not filed. That price index we admittedly were not filed. Just our case is that we have already dispersed admittedly.
bank account
କିନ୍ତୁ ଆପଣ କହୁଛନ୍ତି ନା ସେଟା ଆଉ ଟିକେ ବେଶୀ ହବ ମୋର ଏଇ ଅନୁଯାୟୀ ସେମିତି ହବ
price index
calculation ଠିକ ନାହିଁ ଏଇଗୁଡା
next week I will give a price index. Yes.
ଆପଣ appropriate କୋର୍ଟ କୁ ଯାଆନ୍ତୁ ସେଠି ହିସାବ ପତ୍ର ଦେଖେଇବେ ଏଠି କଣ
ପ୍ରେଜେଣ୍ଟ ପ୍ରାଇସ୍ ଇଣ୍ଡେକ୍ସ ଯୋଉ ଆବସୋଲ୍ୟୁଟ ପଲିସି ସେ
ଭିତରୁ ପଶିବାର ନାହିଁ
ମୁଁ ନେକ୍ସଟ ୱିକ୍ ଆସି ମୁଁ ଆପଣଙ୍କୁ ଦେଖିବି ଜଜମେଣ୍ଟ ଖାଲି ୱିଥ୍ ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଅଛି they have to give it in the absolute present price index.
ଏବା କହୁଛନ୍ତି ଦିଆଯାଇଛି ସବୁ
ସିଏ କହୁଛି 94 ରେଟ୍ ଦେଇଛି 94 ରେଟ୍ ଦେଇଛି
ନାଇଁ 94 ନାହିଁ ସେ ପୁରା କହିଲେ ପ୍ରେଜେଣ୍ଟଲି ଯୋଉ କ୍ୟାଲକୁଲେସନ ତା ରିପ୍ଲାଏ ରେ କହିଲେ
ଏବେ
2004
ହଁ ଏବେ କହୁଛନ୍ତି
94 କୋଟି
they have paid me in 2021 madam. They have paid me in 21
ତାଙ୍କର
on the basis of 2004.
Yes.
And according to you it should be on the present market day when they disbursed it.
They are disbursed in 21.
Right.
Saying it is in as per the
2004
rate.
Yes.
As per 2004 rate.
So what is your case? Your case is that the period on which it was disbursed.
Yes.
The price index to be followed for that year. Where is that? That is section 10 clause.
Section 10. Let me come tomorrow, my lord. Tomorrow I will give the Supreme Court decision directly on this point.
ଆପଣ ଚୁପ୍ ହେଇ ବସିଗଲେ କାଉଣ୍ଟର ଟା ଫାଇଲ କଲା ପରେ ଚୁପ୍ ହେଇ ବସିଗଲେ ନା ରିଜଏଣ୍ଟର ଫାଇଲ କଲେନି ଆପଣ କଣ୍ଟ୍ରୋଭର୍ଟ କଲେ ସିଏ ଆପଣ ସ୍ଥିର ହେଇ ବସିଗଲେ ଆପଣ ଯଦି କହୁଛନ୍ତି ତା ଦେହରୁ କ୍ଲୁ ନେଇଯାଇଥାନ୍ତେ ଯେ 2021 ରେ କହୁଛନ୍ତି ସେ 2004 ଅନୁଯାୟୀ ଦେଇଛନ୍ତି ଆଡମିଟେଡଲି 2021 ପାଇଁ ଦେଇନାହାନ୍ତି ତେଣୁ କିଛି କହିଲେନି ଚୁପଚାପ
And subsequently this is the price index.
ହଁ 2021 ରେ ଏଇଟା ତେଣୁ
I will provide this. Next.
The Lieutenant Counsel for the petitioner seeks for an adjournment, submitting that if necessary, he will file a rejoinder affidavit. Put up this matter, put a saptah for a provision. Yes.
Item 41.
Served with the intervention application, go through it and necessary file.
IN numbers one so key file person.
So I'm post question.
Oh, you have not given the copy.
Now,
IN number so and so, this is an application for intervention. Copy of the interim application has been served on Mr. Gautam Mukherjee and senior advocate in court today, who seeks some time to go through the same and if necessary to file objection to the interim application within a week. Within a week, place this matter in rebalancing from 16th of December 2024. Yeah.
State may be serve a copy. Yeah, more than
42.
41 minutes. State may be serve a copy.
41
Yes, yes.
state.
They have not served a copy to us.
Yes.
IR copy, IR copy can also be served on the current counsel for the state. Item number 41.
41.
41. Yes, 42.
On 42, your lordship directed me, last occasion, your lordship directed me to file the DRT order and I'm filing the repeated notice, they have not appeared. Everything is reflected in the order.
2023.
2022, your lordship.
Yes. Even you are watching the proceeding because
Learned counsel for the 8 latest order uchi learning counsel for the applicant bank present non appears for the defendant.
he has not filed the Bhakta. The counsel I am not appearing there. Counsel who is there?
No.
So how does it matter to you whether he files the Venama or not? The court will come.
On behalf of the petitioner, the counsel who will be appearing there, he has been provided the Bhakta in 2023. This is of 2023. This proceeding. But he has been watching the
It's
proceeding.
totally wrong, your lordship. The order sheet are there. Kindly have a glance to the order sheet.
Way number 154 2024.
Hearing close ହେଇକି ମତେ submit କରିବାକୁ କୁହାଯାଇଛି original document for orders. Not simultaneously two proceedings are there.
That is exactly what we want, that this writ petition has been filed by Ganapati Aluminium.
Yes.
And the prayer is that you want to quash the annexure 3 and 5. Right?
Subsequent proceeding.
Whatever it may be, annexure 3 and 5. The bank has already instituted an original application before the DRT cutter. And notice has been issued. And you are supposed to appear.
Responding that, yes, we have instructed the counsel there.
Again, you are going to that. 23 ମସିହାର original application. ଆପଣ 2000 ସେ latest order ଟା ଆଣିକି ଦେଖଉଛନ୍ତି.
ତା ତଳେ register order ଟା ଅଛି.
6/10/2024.
ହଁ, ଏପର୍ଯ୍ୟନ୍ତ ଆପଣ appear କରିନାହାନ୍ତି. So take ଆପଣ ଇତେ order sheet ଟା
ପୁରା order sheet.
That counsel when asked, he said no, I've been watching because the order
Watching in this.
ମାନେ argument close ହେଇକି ମତେ original document file କରିବା ପାଇଁ କୁହାଯାଇଛି.
Oh, he is playing a hide and seek. So the moment the things will be against them, he will be interfering. How can it be?
Not possible. Your lordship
must be
dispose
very
of the matter
clean in your
because the
approach.
writ petition is not maintainable. Last occasion, you already filed the latest judgment also.
We are disposing of this writ petition. We are asking you to ask your counsel to take steps there. Don't watch further.
Yes, yes.
Already you have watched for 1.5 years maybe. This writ
and one thing
petition.
more, Lord.
All right.
All the points that has been
That
Yes,
this writ petition has been filed by.
And they will be supplying us copy. They have not provided the copy of the paper.
Here you have to supply.
ଆପଣ ଯୋଉ moment ରେ ସିନା appear କରିବେ ସେ
order sheet ଟା
notice ଟା ଯାଇଥିବ. ଆପଣ ଯେତେବେଳେ ବସିକିନି watch କରୁଛନ୍ତି କଣ ଚାଲିବ ଆଉ copy କଣ ଦେବେ? Ganapati Aluminium with a prayer for such and such date. Learned counsel for the opposite party bank submits that the DRT is in session over the matter and OA number 154 of 2023 is sub judice at the instance of the bank. And in that case, notice has been issued, but the petitioner has not yet appeared. In support of such contention, the learned counsel for the bank has filed the order sheet dated 23/10/2024, which shows that none appears for the defendants. since the matter relief sought for in this proceeding, in this writ petition, can be adjudicated by the Learned Debt Recovery Tribunal, we are not inclined to entertain this writ petition, giving liberty to the petitioner to take steps before the DRT cutter and raise necessary funds there, raised accordingly. It will be also the
Deeply obliged, Your Lordship. Urgent copy, Your Lordship.
ଏଗୁଡା କଣ ବ୍ୟାଙ୍କ ଆପଣ ନଦେଲେ କି ଆପଣ କେମିତି କରିବେ କେମିତି ଏଇଟା ଜେନେରାଲ ଏଇଟା କଣ ଆମେ କହିବୁ ତାଙ୍କୁ
Deeply obliged, Your Lordship.
yes next
Weekly list item number 1.
Convicted on both the applicants convicted on 302 30.5. Sentence is life each and the 1 year.
I'd admit call for the trial court record.
Item number 2.
My lord, that earlier present appellant's bail applications was rejected on merit in the year 2020. That is the order dated, my lord.
Who is there is a prisoner's petition for appointment of Mr. Srinivas Parija and his associates. That is how you have entered appearance. Wakalatnama filed. I'll take down pay you the prisoner's petition at flag X and the prisoner's petition in which request has been made for engagement of Mr. Srinivas Parida as his advocate.
Paricha or Parida?
Parija. ये लिखी जी परीक्षा
The Paricha लिखी.
अच्छा और भी नंबर कौन लिखछन भी नामटा कोड परिजा लिखछन अच्छा Mr. Srinivas Parija and his associate filed power which is accepted. The name of Mr. Prashanna Kumar Mishra shall not be reflected in the cause list henceforth. कुहतु कौन है
Was rejected on 11/2/2020.
कौन सा
It is said that
11/2/2020
again, my lord, I have filed this application, my lord, for bail under changing circumstances that in the meantime, my lord, period of detention, my lord, only under changing circumstances.
What is the period of detention?
That my lord, in at present, my lord, that this present petition is behind bar for 10 years, 7 months, and 5 days.
No, date of custody कौन
Date of custody
कोड़िए
2014
मैंने 10 years से गला ठीक है कोड़िए चल तो मेरी ट्रिप तो रिजेक्ट हुई थी तो कोड़िया लोग कोई है जजमेंट तो देखिए What is the allegation?
allegation, my lord, that this present appellant, my lord, borrowed cash of rupees 20,000 from the present, my lord, informant. And then this is, my lord, that informant borrowed cash of rupees 20,000, my lord, from the deceased. And for that reason, my lord, when he asked for payment, he told him that you come to my house and there I will pay the amount. That in presence
Who
of
borrowed money? From whom?
that the present,
You are confusing
and
whether
my lord, this is informant, my lord.
deceased is the informant.
This is the informant.
Then
Oh,
deceased informant you are saying?
My lord, here, my lord, the appellant borrowed cash of rupees 20,000 from the present informant.
All right. From the informant. Huh?
Informant.
Then
When that informant is
again.
see.
Obviously.
Please come to paragraph
Sir,
number
paragraph 2 টা পড়ে দিন তো better.
Come to paragraph number 2.
The appellant was charged for the commission of the offense under section.
That is not paragraph number 2. That is paragraph number 1.
That one of to my lord, prosecution case in brief is that the occurrence was taken place on 16/4/2014 at about 10 p.m. in the night in the house of the accused situated at village S.K.Sahoo of village Bagha under R. Udayagiri PS. It was alleged by none other than the wife of the deceased, namely Timothy Rebecca Raita, that prior to the occurrence, the accused Abhimanu Gowda, who is the present appellant before the lordship, had taken a hand loan of rupees 20,000, and to collect the money, the deceased went to his house in the night, and the accused picked up the quarrel with him and brought out a handmade pistol and opened fire, for which the deceased sustained bleeding injury on his chest. At that time, another person, namely Bancha Nidhi, who is the PW2, he has supported the prosecution case, who was present also, received minor injury on his person. She called the nearby person and shifted her husband to R. Udayagiri CSC, where he died, and she lost the report at R. Udayagiri PS. The said report of the information has been treated as FIR, and the IO of this case, after completion of his investigation, submitted the charge sheet.
So that injured is the eyewitness to the occurrence.
Yes, my lord.
Who is that injured?
That PW2, my lord. Banchani. There are two witnesses, my lord. Try to pacify. Yes, my lord. And my lord, the PW9, who is the doctor, he has also mentioned that injury, regarding that injury puncture.
The accused brought out a gun from his house, part saw, so and so.
So
Okay.
point blank.
That is also corroborated by the doctor's evidence.
Other evidence, other not supported the prosecution case, but PW1 and 2, they are the sole eyewitnesses to the occurrence. PW2, 1 is the informant, and PW2, who is also the present at the spot, and he has also the
Doctor is PW9.
Doctor is PW9, my lord. He has also supported the prosecution's case.
Death was due to injury on the vital part of the body. Oh, how many cases you have got? Apart from this case,
Antecedent, there is no antecedent.
no antecedent.
All of those are
Counsel for the state. Land counsel for the petitioner submits that the petitioner was taken into judicial custody on 24 2014, and the prosecution case is mainly based on the statement of the injured eyewitness PW2, which is getting corroboration from the doctor bracket PW9 who conducted post-mortem examination. It is further submitted that earlier the bail application of the petitioner was rejected by this court by order dated 11/2/2020. And since petitioner has remained in custody for more than 10 years and 7 months, and paper book has not been prepared, and therefore there is no chance of early hearing, bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of PW2 and PW9. Considering the submission made by the learned counsel for the respective parties, the evidence available on record, particularly the evidence of PW2 and PW9, were not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months by usual terms and conditions. Yes. That usual condition. Yeah.
Item number 3.
Stay realization of the fine amount. Miscase of payment. Miscase for stay
Stay realization of fine. That is done.
Item 3.
They have been referred. That's now confirmation. Some of the rest we have the report can be carried.
The day after tomorrow, the learned counsel for the state submits that the IIC, the concerned IIC has already sent the report regarding the conduct of the petitioner while on interim bail, and the matter may be taken off day after tomorrow. It is this matter on 4th of December 2024. 5th, all right, on 5th of December 2024. Yeah, देखिए Mr. Raman
नहीं कोर्ट नहीं
हाँ
फिफ्थ कोर्ट नहीं
नहीं এটা first type ratio. You combined it got a lunch
consolidated कर दो
consolidated कर दो.
Item 4.
And sentenced to life imprisonment.
Your bail application was earlier rejected. You are not aware. Wait.
नहीं होता है
नहीं मुझे इंटरव्यू पे लगा कि हाँ इंटरव्यू पे
Interim
लगा
bail
इसमें गई चले 28/10/2022 रे So what is the offense here?
302 307
Mother-in-law. Two eyewitnesses are there. PW1, who is the wife of the appellant, the daughter of the deceased, and another is her own son. PW7 is the minor son of the appellant. The offense has not been released. And he alleged that
You are taken into judicial custody when?
Custody on 4/4/2013. He died.
What is the name of the deceased?
Noor Jahan Begum.
Noor Jahan Bibi.
Begum.
After
What the son-in-law? What the witnesses have stated, eyewitnesses? PW1 tower पर trial court. PW1 is your wife. Come to PW1, paragraph 2.
Date of occurrence, accused came to the house at around 10:30 AM and called my son to take chocolate with him. My son came to him without taking chocolate from the accused and informed about the arrival of the then accused asked my mother to transfer her landed property into his name. My mother told that she would transfer the property in my name and also in the name of my son. This annoyed the accused. He left the spot, giving threat to me and my wife, my mother. Then the accused came again in the night. My mother was sitting to her to take dinner after offering namaz. He suddenly gave blows by a sharp cutting weapon to his head, back, and chest of my mother. My mother fell down and shouted. The accused gave blows on that weapon to my head. I shouted. I then opened the outside door of my neighbor and fell down. The accused fled away from the spot.
With the doctor?
Dr. Malan, PWP is the doctor who initially treated both the injured PW1 and the deceased. The Lordship had come to the injured. This occurrence took place on 25 March 2013.
25 March
2013.
13.
And injured PW3 evidence, he found 3 lacerated injury, 4 injuries are there, which are of simple in nature on the injured PW1. Then next page, my lord, he found 2 lacerated injury and 1 there is a tenderness on the left side, left chest. Then my lord,
Right chest.
then my lord, he mentioned paragraph 5. I suspected the case of head injury and referred the injured to SC Medical College and Hospital, Qatar. This is my report marked Exhibit 5 and this is my sign in Exhibit 5. But the patient did not go to SC Medical College and Hospital, Qatar and remained under treatment in surgical ward of DHH Bhadrak till 27/3/2013. And she also again referred to SC Medical College and Hospital on that day by Dr. B.M. Panda as her condition was critical. On 13/6/2013, I received a query from the IIC. But there
leave it. What about the PM report?
PM, he died on 14th. 25 PM report. PM doctor is PW2. This is died on 14th.
14/4/2013.
About 19 days thereafter she died.
Date of occurrence होची 25/3/2013 ଆଉ ଏଟା ହେଲା 14/4/2013 अच्छा ଏଇ ଯୋଉ ଡକ୍ଟର ଟି ତାକୁ ଇନିशिয়াली ट्रीटमेंट कला ସେ କଣ ହେଲା ରେଫର कला ନା କଣ
ରେଫର କଲେ ଗଲେ ନାହିଁ ମାନେ ତମେ ପଡେ ହେଡ୍ इंजरी ସସ୍ପେକ୍ଟ କରୁତାଉ ଜଣା ଆମେ ଯିବୁନି ଆମେ ଏଇଠି ଟ୍ରିଟମେଣ୍ଟ ଦେ ରିମେ
अच्छा अच्छा पैराग्राफ 3 रे होची डिड नॉट गो टू द एससी मेडिकल कॉलेज
पैराग्राफ
6 अच्छा ओके
सस्पेक्ट पैराग्राफ 5
हां
पैराग्राफ 6
I suspected there was head injury and referred the injured to SCB.
Again.
But the patient did not go to SCB and remained under the treatment of surgical ward of DHS Bhadrak till so and so on. Then she was again SCB, tapare refer karala. As her condition was critical. Okay. 11 years. Custody होची 4/4/2013. 11 वर्ष 7 मास 8 मास
Yes, then.
Okay, 14. At that time of judgment 2018. Now, what 55 years?
7 ମାନେ ବର୍ତ୍ତମାନ 21 ବର୍ଷ
ପିଲା ତାର ଘରେ ଅଛି।
Or the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submit that the petitioner is in judicial custody since 4/4/2013. The occurrence in question took place on 25/3/2013, and the prosecution case is that the petitioner assaulted the deceased, who was his mother-in-law, as the deceased was not inclined to transfer the landed properties in the name of the appellant alone. The learned counsel for the petitioner further submitted that the injured was first treated in DHS Bhadrak, and injured hala se jo Nurjaham bibi to ଆଉ ଗୋଟେ କି injured ଅଛି
ନିଜେ ତା wife ନିଜେ
acha injured was treated in so and so, and the doctor advised him, doctor referred the injured to the SC Medical College Hospital as he suspected head injury, but the injured didn't go to the SC Medical College Hospital and remained under treatment in in surgical ward of the DHS Bhadrak till 27/3/2013, and again she was referred to SC Medical College. The land council submits that the death took place on 14/4/2013. The land council further submits that since there are two eyewitnesses to the occurrence, that is PW1 and PW7, who are the wife and son of the appellant.
ଆୟୁବି କହୁଛି ସେ actually ପୁରା total ଭଦ୍ରକରେ ହିଁ treatment ହେଲା। ଭଦ୍ରକରେ ଜମା
ତ ଯାଇନି ତ
SCB
ଯାଇନି
but even on the second occasion also the deceased was not had not been to SC Medical College for treatment, and he at Bhadrak he died. Bhadrak he died. The land council submits that PW1 and PW7, the wife and so are the eyewitnesses to the occurrence, and in view of the available material on record, and particularly the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail and place the evidence of PW1, PW3, PW7, and PM doctor के थे PW2 था serial development. Two eyewitnesses like them, PW1 and 7, and the doctors, that is PW1, 3, and 4. Considering the submission made by the land counsel for the respective party, the nature of evidence available, the period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item number 5.
9/11, 9/12/2020. Yes.
Item 7.
File the surrender certificate for 19
19. Learning Counsel for the appellant submits that the surrender date is fixed to 19/12/2024. In view of such submission, matter be placed in the second week of January 2025. Learning Counsel for the appellant shall produce the surrender certificate. Yes.
Item 8.
କଣ ବୁଲିଛୁ? Any objection you find?
My lord,
What is
there
your
are no
objection?
objection. There are two letters has been sent, but till date they are not responding, my lord.
ये काहाକୁ ले
IAC Buden and the Superintendent of Subjail Nuapada. By order letter dated 29/11/2024 on letter has sent and another 20/11/2024.
ନାଇଁ ନାଇଁ ଏଇଟା ତ ଆମର ମେମ୍ବର ସେକ୍ରେଟାରୀ ଲେଖିଛନ୍ତି ସୁପରିଟେଣ୍ଡେଣ୍ଟ କ୍ରିମିନାଲ ଆପିଲ କୁ କଣ ଲେଖିଛନ୍ତି? So and so passed in so and so communicated. This office received a letter from the Land and Secretary so and so along with the prisoner's petition, copy of the
One percent transfer.
ये जो सुपरिटेंडेंट भवानी पटना कौन लिखला? 1697 of 2024 is an application for condonation of delay. Peru the objection filed by the Land Council for the state, since it is a case where the petitioner, appellant, has been sentenced to undergo imprisonment for life under section 302 of the Indian Penal Code. So also 3 years and fine for offense under section 201 of the Indian Penal Code. We are inclined to condone the delay in filing the CRLA. Accordingly, delay is condoned. Hard admit call for the trial court report. Yes. After the trial court bail application कहेंगे अच्छा interim application for bail and आप कौन हो देखेंगे stay relation of fine to be considered after receipt of the trial court report. Yes. Delay condoned, appeal has been admitted, your application for bail and stay relation of fine, it is to be considered after receipt of the trial court record. है ना? हाँ.
Item 39, I am ready for hearing maybe tomorrow, madam, because my madam
Just
is
a
ready by
minute.
16.
What about we are going serially? Huh? Oh, sure. 15 तक कौन है?
Item number 15.
Yes, sir. এই অর্থটা বিষয় 18 বিষয় non appears for the you are there in Biswal, you are there in item number 16. Who is there in will take up this. Item number 17. Certificate 19টা কোন সারেন্ডার সার্টিফিকেট নট রিসিভ লেখাই 19টা দেখি प्लीज देखो जो जो मैटर আমি টেক আপ করি দেখো না अंदर 5 ରେ ଯାଇଥିଲା ଇଏରେ ଇଣ୍ଟରିମ୍ ବୋଟେ ଯାଇଥିଲା କୋଇଟଲା ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ପଳେଇଲା କଣ देखिए the item number 19 non appears for the appellant. The appellant was directed to be released on interim bail for a period of 3 months as per order dated 15/5/2024 in IA number 139 of 2023. Surrender certificate has not been filed. Let instruction be obtained from the London Trial Court as to whether the appellant has availed the interim bail period as per the aforesaid order and surrender at right time or not, and if not, what steps have been taken for his arrest. Report to be furnished within such and such date, file be placed before the registered judicial. Hello. Next. Deepak Kumar Sahu, you are there ready? Okay. Paper ready. Show ready, Korea ready. After Rita Singh from guess charity दिया. Okay. Yes, Mrs. Vishwas.
24
ठीक है
24
ठीक है भाई 16 20 24
Yes. May I please, my lord?
Yes, just a minute.
Yes. The appellant was charged and tried the under section.
Just a minute.
period of detention already undergone by the convict.
If you come to page number, internal page 12, running page 14, paragraph 20. Paragraph 20.
From the aforesaid fact and circumstances, it is not only proved but become clear that the deceased used to take cows to tend them in the river bed by the side of the groundnut crops field of deceased. Of the accused. 2. The cows of the deceased had damaged the crops of the accused prior to the incident. 3. For the reason the accused had given threatening to the deceased and to the family members of the deceased with dire consequences, and even to murder the deceased if again his cow will damage the crops of the accused. The witnesses saw on the date of incident about the damage of the crops of the accused. 5th, such damage of the crops of the accused caused annoyance to him. When the cow went from the house of the deceased to graze, it had its tail, and the tail of the cow was cut and was detached from the body, whereafter both the injured cow and cut cow tail produced before the VS, who opined that cow tail belongs to the cow of the deceased. Being annoyed, the accused became angry and caught the tail of the cow of the accused, which damaged the crop. Accused prepared with cow tail to press the neck of the accused. When the deceased protested, the accused overpowered him and at last killed him, pressing his neck by means of cut cow tail. The accused had the knowledge that if the neck of the deceased could be pressed by means of the cut cow tail, then the deceased would die easily without any difficulty and blood shed. The nature, location, age, number of injury, and weapon of offense used to kill the deceased find support from medical opinion. Due to previous damage of the crop by the cow of the deceased, there was hostility between the accused and the deceased. So, due to such enmity, the possibility of the accused committing the murder cannot be ruled out. The time gap between the last seen theory of the accused for the deceased with that of his death is so short that no person except the accused had the access to the deceased to kill him. The motive, though not important to be proved in every case, yet here the motive of the accused is nothing but remove the deceased from his path for all the times to come in order safeguard his groundnut crop. As there is no eyewitnesses to the incident, well, that is the important. As there is no eyewitnesses to the incident, and as all the above circumstances fill up the chain of link from beginning to end, so that the accused is the author of the crime. So it is within the special knowledge of the accused to produce believable evidence that did not kill the deceased. The accused could not satisfy the court from out of his special knowledge as to how his deceased friend died near his groundnut crop land within the short time gap when the accused was last seen by him. The investigation about the seizure of weapon of offense, cartel, cutlery, wearing apparels, etc. from the spot is also a circumstances which corroborate from other factor and evidence on record to believe that the accused is the author of the crime. Last but not least, is the non-explanation of the accused about his special knowledge as to what happened thereafter when the deceased was last seen with him till his dead body was found on the river bed.
So, the London trial court had jotted down as many as 17 circumstances against you.
Again.
So, who are the witnesses on each of these circumstances? Admittedly, there is no direct evidence.
Again, so it more column number 15.
That's all right.
Again.
But ଏଇ ଯେତିକ circumstance ଆସିଲା
ଆଜ୍ଞା
ଏ ପ୍ରତ୍ୟେକ circumstance ରେ କିଏ witness have you
ହଁ
କରିଛନ୍ତି ଗୋଟେ କି ଚାର୍ଟ
ଚାର୍ଟ ମୁଁ ଫେୟାର
ସିଧା ପଳେଇ ଆସିଲେ ଆର୍ଗୁମେଣ୍ଟ
ନା ଚାର୍ଟ ମୁଁ ଫେୟାର କରିନି କିନ୍ତୁ ମୁଁ ପ୍ରିପେୟାର ଅଛି
କଣ ପ୍ରିପେୟାର ଅଛନ୍ତି
जो
with the witness to the last scene
last scene my lord all the witnesses my lord double one
ଆଇଓ ମାନେ ଆଇଓ ଡାକ୍ତର ସବୁ ହଉଛନ୍ତି
ନାଇଁ ନାଇଁ ଆଜ୍ଞା ଯେତିକ ତାଙ୍କର
ପଚାରୁଛୁ ପ୍ରଶ୍ନଟା ଠିକ ସେ ଉତ୍ତର ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ଆମେ ପଚାରୁ ଲାଷ୍ଟ ସିନ୍ ନା ସବୁ ୱିଟନେସ୍ ଭିତରେ
ନାଇଁ
ଡାକ୍ତର ବି ଅଛନ୍ତି ଆଇଓ ବି ଅଛନ୍ତି ସେମାନଙ୍କ ଲାଷ୍ଟ ସିନ୍
नो my lord
ଆଉ ତାହେଲେ have you why didn't you prepare the a chart that this is a circumstantial evidence
my lord
ଏଇଟାକୁ ସିଏ ତ ଜଟେଡ୍ ଡାଉନ୍ କରିଛନ୍ତି ତାକୁ କିଛି ଅସୁବିଧା ହେଇନଥାନ୍ତା
ଆଜ୍ଞା
ତା ଦେହରୁ କାଢିକିନି ବାହାର କରିଛନ୍ତି as many as taken pain to jot down 17 circumstances
ଆଜ୍ଞା previous all the witnesses my lord they have categorically stated about the previous dispute no doubt my lord all the witnesses my lord that
ଖାଲି previous dispute ନୁହେଁ ବାବୁ କେତେ ଗୁଡା circumstances ଦେଇଛନ୍ତି
ଆଜ୍ଞା
apart from threatening to last scene to leading to this so many things have been given
my lord
if you are not prepared be prepared come with a chart we just want to know
ଆଜ୍ଞା
that a circumstance ରେ a witness
ଆଜ୍ଞା
maybe on a
my lord
particular circumstance maybe two or more
my
or
lord
maybe one witness is
my
there
lord my lord
so a witness ଦେଇଛନ୍ତି prosecution ଦେଇଛନ୍ତି ତ ଆମେ ଏଇ circumstance wise ଆମେ ଦେଖିବୁ
ଆଜ୍ଞା ଆଜ୍ଞା
ହେଲା
ନୋଟ କରିଦେବି
ତେଣୁ ନୋଟ କରି ମାନେ you do it that would be easier
yes my lord yes my lord
place the matter
ଆଜ୍ଞା
କାରଣ ଆପଣଙ୍କର କ୍ଷେତ୍ରରେ
ଆଜ୍ଞା
ଆସୁଛି ଯେ ସିଏ ବାରମ୍ବାର ନେଇକିନି
ଗୋରୁ ଗାଈ ଚଢେଇକି ଆଜ୍ଞା ଫସଲ ନଷ୍ଟ କରୁଥିଲା ସେଥିପାଇଁ ଆଗରୁ ତାଙ୍କ ସହିତ ମୋର ବଚସା ବି
ତାଙ୍କ ଘରେ ମଧ୍ୟ କମ୍ପ୍ଲେନ କରିଛନ୍ତି
ତାଙ୍କୁ ବି ମଧ୍ୟ କହିଥିଲି
ଧମକେଇଛନ୍ତି ବି ଯାହା ହଉ
ଆଜ୍ଞା
ଏବଂ ଯୋଉ ଘଟଣା ଦିନ ମଧ୍ୟ ସିଏ ଗାଈ ନେଇକିନି ଆସି ଚରେଇବା ପାଇଁ
ଆଜ୍ଞା
ତେଣୁ ଚରେଇବା ପରେ ସିଏ ଆଉ ଘରକୁ
ଫେରିନି ମତେ କିନ୍ତୁ ତା ସାଙ୍ଗରେ କେହି ଦେଖିନାହାନ୍ତି କେହି ସାକ୍ଷୀ ବି କହିନାହାନ୍ତି
ଲାଷ୍ଟ ସିନ୍ ପୁରା you see this ମୁଁ ସେଇଥିପାଇଁ କହୁଥିଲି
ଆଜ୍ଞା
ଯେ
ନାଇଁ ମତେ କେହି ଆଜ୍ଞା 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 yes my lord but regarding my lord last scene theory is concerned my lord no ଆଜ୍ଞା ତା ସାଙ୍ଗରେ ମୁଁ ବୁଲୁଥିବା କି ସାଙ୍ଗରେ ଯାଇଥିବା
just a ground number 16 the 16 number କୁ ଆସନ୍ତୁ
ଆଜ୍ଞା the accused could not satisfy the court from out of his special knowledge as to how his deceased friend died near his groundnut crops land within the spot time gap when the accused was last seen by him ସିଏ ଯେତେବେଳେ ମରିକି ପଡିଥିଲା ମୁଁ ତାକୁ ଦେଖିକି ଆସିକି ତାଙ୍କ ଘରେ ଖବର ଦେଲି that is the allegation and that is the statement of all the witnesses
ଆପଣଙ୍କର କ୍ଷେତ୍ରରେ
ଆଜ୍ଞା
ଡେଡ୍ ବଡି ଟା ପଡିଛି
ଆଜ୍ଞା
ଯୋଉ
ମୋ କ୍ଷେତ୍ରରେ ନୁହଁ ଆଜ୍ଞା ଗୋଟେ ହୁଡାରେ ପଠା ନଈ ପଠା ସେଇ ନଈ ପଠାରେ ଆଜ୍ଞା ଡେଡ୍ ବଡି ଟାକୁ ମୁଁ ଦେଖିଲି ଦେଖିକି ଆସିକି ଆଜ୍ଞା ମୁଁ ଗାଁରେ ତା ଘର ଲୋକଙ୍କୁ ଖବର ଦେଲି
ନିୟର ହିଜ୍ ଗ୍ରାଉଣ୍ଡନଟ୍ କ୍ରପ୍ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି ଏଗୁଡା ସବୁ ମାଇନ୍ୟୁଟଲି ଯାଆନ୍ତୁ
ଆଜ୍ଞା
ଦି circumstance is near your groundnut crop
near his
the
groundnut
body was lying
ଆଜ୍ଞା
and you were the person who was last seen with the deceased that is the one of the
ଆଜ୍ଞା
ଯଦି ୟା ପାଇଁ କେହି circumstance ନାହାନ୍ତି
ଆଜ୍ଞା
ଆଇ ୱିଟନେସ୍ ଆପଣ କହିବେ there is no eye witness there is no witness to this ହେଲା ଏଇ ଯୋଉ last scene
ଆଜ୍ଞା
ଏଇ ଯୋଉ କହିଛି ମନେକର ଆପଣଙ୍କ ଏଗେନଷ୍ଟ ଗୋଟେ କଟାରିଟା ରିକଭର ହେଲା
ହଁ ସେଇଟା ଆଜ୍ଞା ହେଇଛି
ତ ଦି ଆଇର ଛଡା ଏଇ ୱିଟନେସ୍ ତ if you do it in that way it would be easier not only to you to address this court and to this court it is not that few circumstances are there 17-18ଟା circumstance ହେଲାଣି ନା
ଆଜ୍ଞା
ତେଣୁ ଆପଣଙ୍କୁ ସେଇ ଅନୁଯାୟୀ ଜଟ୍ ଡାଉନ୍ କରିବାକୁ ପଡିବ
ଆଜ୍ଞା
ଏବଂ ଆପଣଙ୍କୁ ରେଲେଭାଣ୍ଟ ଜିନିଷ ଗୁଡାକ ଦେଖିବାକୁ ପଡିବ
ଆଜ୍ଞା
6, 7 and 8 6, 7 and 8
ସମସ୍ତେ କହୁଛନ୍ତି ଲାଷ୍ଟ ସିନ୍ ଥିଓରି ମାନେ ବଞ୍ଚିଥିବା ଅବସ୍ଥାରେ ମତେ ତା ସାଙ୍ଗରେ କେହି ଦେଖିନାହାନ୍ତି rather
as many as 22 witnesses
22 witnesses are there
ହେଲା
and VSS doctor also
ହଁ ସେ କହିଛନ୍ତି ସେଇ ଗାଈର ସେଇ ଲାଙ୍ଗୁଡ ବୋଲି ସେ କହିଛନ୍ତି କିନ୍ତୁ କେହି କହିନାହାନ୍ତି ମୁଁ ସିଏ ବଞ୍ଚିଥିଲା ବେଳେ ତାର ମୋର ସାଙ୍ଗ ହେଇକି ବୁଲୁଥିବାର କେହି କହିନାହାନ୍ତି ରାଦର ହି ୱାଜ ଡେଡ୍ thereafter this matter was reported before the village peoples and the family member of the deceased and previous enmity is there and other aspects my lord but nobody seen the that I was traveling with the deceased before
one thing is that see you ଜମିଟାରେ ସେ ଡେଡ୍ ବଡିଟା ସେ ପିଲାଟାର ମିଳିଲା
ଆଜ୍ଞା
ସେଇଟା ଆପଣ କହୁଛନ୍ତି ଏଇଟା ଆପଣଙ୍କର ଜମି
ନା ସେଟା ହଉଛି ନଈ ପଠା ସେ ନଈ ପଠାକୁ ବିଭିନ୍ନ ଲୋକମାନେ ସବୁ ଚାଷବାସ କରନ୍ତି
ସେ ଗ୍ରାଉଣ୍ଡ ନଟ୍ ଫିଲ୍ଡ ଟା
ଆଜ୍ଞା
ଯୋଉଟା ସେଇଟା ଅନ୍ୟମାନେ କହିଥିବେ ଯେ ଏଇ ଗ୍ରାଉଣ୍ଡ ନଟ୍ ଫିଲ୍ଡ ରେ ସିଏ ଚାଷ କରୁଥିଲା ବୋଲି ଆପଣଙ୍କର
ଆଜ୍ଞା
ଆଜ୍ଞା ତ ଅଛି ଆଉ କହୁଛନ୍ତି କିଛି ନାହିଁ କେମିତି ଆରେ ମାନେ ଏଠି ହୁଏତ ଆପଣଙ୍କ ନାଁରେ ସେ ଜମିଟା ନଥିବ କାରଣ ସମସ୍ତେ ନଈ ପଠାରେ କରୁଛନ୍ତି
ଆଜ୍ଞା
ତେଣୁ ଆପଣ ଯୋଉ ନଈ ପଠାରେ ଯୋଉ ଏରିଆ ଟା କରୁଛନ୍ତି ଆପଣ ବାଦାମ ଲଗେଇଥିଲେ ତ ଆପଣଙ୍କ ବାଦାମ ଟା ସେଠି ଯଦି ନଷ୍ଟ କରୁଥିଲା ଗୋଟେ ଛୁଆର ତାକୁ ବାରମ୍ବାର ଧମକେଇଥିଲେ ତାଙ୍କ ଘରେ ଯାଇ ଧମକେଇଥିଲେ ସେ ଡେଡ୍ ବଡି ଟା ସେଇ ଛୁଆର ଇଏରୁ ମିଳିଲା ଏବଂ ତାର ଗାଈ ଯୋଉ ନେଇ ଆସିଥିଲା ସେ ଗାଈର ଲାଙ୍ଗୁଳ କଟା ହେଇଛି ସେଇ ଲାଙ୍ଗୁଳ ତା ବେକରେ ତାକୁ
ମରା ହେଇଛି
ଷ୍ଟ୍ରାଙ୍ଗୁଲେସନ ହେଇଛି
ଆଜ୍ଞା ଏବଂ ନେକ୍ ଇଞ୍ଜୁରି ମଧ୍ୟ ଅଛି
ନାହିଁ କଣ ଏଇଗୁଡାକ ଏତେ ସର୍କମଷ୍ଟାନ୍ସ ଅଛି ତାକୁ ହାଉ ୟୁ ଡିଲ୍ ୱିଥ୍ ଦି ସର୍କମଷ୍ଟାନ୍ସ ଦ୍ୟାଟ୍ ନାଇଁ ଏ ସର୍କମଷ୍ଟାନ୍ସ ଆକ୍ସେପ୍ଟେବୁଲ ହବନି ଏଇଟା ଆକ୍ସେପ୍ଟେବୁଲ ହବ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ଗୁଡାକ ଆକ୍ସେପ୍ଟେବୁଲ ହେଲେ ମଧ୍ୟ ଚେନ୍
କମ୍ପ୍ଲିଟ ହଉନାହିଁ
ତେଣୁ
ଆଜ୍ଞା
that way you present the case ଆଉ ସବୁ ଖାଲି ନାଇଁ କରିଦେଲେ କଣ 22ଟା ସାକ୍ଷୀ ଦେଇଛନ୍ତି ପ୍ରୋସିକ୍ୟୁସନ
ଆଜ୍ଞା
in that way you show your preparation you come ready tomorrow
next week ତାପରେ ଟାଇମ ଟିକେ ଦେଇକି ଭଲ ରକମ ନୋଟ ପ୍ରିପେୟାର କରିକି
ଖରାପ ରକମ ପ୍ରିପେୟାର କରି
ନେକ୍ସଟ
ଆପଣଙ୍କୁ ଗୋଟେ ଦାୟିତ୍ୱ ଦିଆହେଇଛି ଜଣେ ଲୋକଙ୍କୁ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି 302 ରେ ଆପଣ କିଏ କହୁଥିଲା ଖରାପ ପ୍ରିପାରେସନ ଆସି ଡିଭିଜନ ବେଞ୍ଚ ରେ ଛିଡା ହବାକୁ get prepared
ଆଜ୍ଞା ସେ ତ ପୁରୀ କୋର୍ଟ ବି କରିଦେବେ ମଚ ମୋର କମ୍ପିଟେଣ୍ଟ ସେ ପୁରୀ କୋର୍ଟ ରୁ ବି କେସ୍ କରିବାକୁ ରେଡି ଥିଲେ ନା
ଠିକ ଅଛି
ପୁରୀ ଗଲା ୱିକରେ
ହଁ ଆପଣ ଆରେ ହଁ ସତ କଥା ଆପଣ ସେଦିନ ପୁରୀ କୋର୍ଟରୁ ଯାଇକି କହୁଥିଲେ
ଏ କେସ୍ କରିବା ପାଇଁ
ନାଇଁ
ଆପଣ ଆମେ କହିଲୁ ନାଇଁ ଆପଣ ଆସିକି ଏଠି କରନ୍ତୁ
ଆଜ୍ଞା
ସେଠି ତ ବୋଧେ ପେପର ବୁକ୍ ବି ନେଇ ନଥିବେ
ନା ମୁଁ ନେଇଥିଲି
ମୌଖିକ ଦୀପଦ କହିଦିଅନ୍ତେ ବେଲ୍ ଆପ୍ଲିକେସନ
ନା ମୁଁ ସାଙ୍ଗରେ ଆଜ୍ଞା ରଖିଥିଲି
get ready
ଆଜ୍ଞା
we
next
are
week
not adjourning this matter matter will be there
ଆଜ୍ଞା
tomorrow we are going to take Mrs. Biswal's matter
ଆଜ୍ଞା
and we may take up this matter day after tomorrow ହେଲା
ଆଜ୍ଞା
Item 19, the last matter, that he is already in the custody, but the surrender certificate not.
We have, since you are not producing, we are calling for a report from the land and trial court whether he has surrendered.
He has surrenders in the month of August.
We do not know. You are not producing. How can we know?
Yes.
So
he is in custody since 2010, sir. So I am ready to dispose of.
We have just asked for the land and trial court to submit a report as to whether he has surrendered or not.
Yes.
That's all.
Yes. Can it be taken up next week? Can we dispose of?
No. We have already called for a report. The report will be received, and once it is found that he is in custody, it will be taken up. We are not adjourning.
Sir.
Just call for a report. Yes.